Please, Your Lordship.
Yes.
I beg to mention one RSA 135 of 2016 for listing on 1911, 19 this next week, my lord. I had
In which column?
order column, my order.
Orders.
Okay.
Then on 19 Lordship, so many hearing cases. So on 20,
19 Tuesday. It is a hearing matter. Earlier the matter
hearing matter.
already.
Hearing matter in the month of November not possible.
My lord, then
December.
December 3.
Possible.
On 5th December. 5th.
Two matter, my lord.
2 meters.
Another one is 46 of 16. Due to paucity of time on several occasions, the matter has not been reached.
1 on 5th and 1 on 10th.
Highly obliged.
May it please your lordship, I beg to mention a listing of a RSA matter for hearing, your lordship.
Hearing.
Yes, lordship. On
When?
5th December, your lordship.
5th December.
10th December. 10th December.
Yes, lordship.
May please lordship, pray for listing lordship MAC appeal. Lordship for orders.
When?
Lordship 18.
18.
Lordship
18 of this month.
Yes, lordship. Urgency is there, lordship.
Okay.
What urgency? What urgency?
Lordship 50% amount not granted in this case, lordship.
Acha, okay. When it was admitted?
Lordship last posted, lordship 27/6.
Acha, okay.
Same prayer, Lordship.
When?
Lordship, the last posted Lordship in 1/21/2024, another Lordship 11/5/2024, Lordship.
Okay.
Under which column?
Candidate, Lordship.
Order. Order.
Same.
On 20.
Orders.
1 on 22nd, 1 on 25th. Okay. 1 on 22nd November, another on 25th. 2 days.
May it please your lordship.
Ah.
Your lordship, I beg to mention this second appeal for listing.
When?
The old pending matter.
When?
Maybe in the month of December. It should come in the.
Oh, hearing.
Yes,
Hearing.
Hearing.
On 19th.
90s. Obliged.
For listing of the CRP IO lordship.
When?
Orders.
When?
Next week, any day from 22nd.
Next week, 22nd.
Obliged.
Lordship, I beg to mention for CRP IO Lordship. Lordship, in this case, Lordship, stay will be there against us, Lordship. So Lordship, kindly list.
Stay will be there.
Yes, Lordship.
It is not there now.
Lordship, against us, Lordship.
It is there or not there?
Lordship, there, Lordship. Stay
There.
There, Lordship. Yes.
Acha.
Lordship, kindly listed on sir, Monday, Lordship.
Next Monday?
Yes, Lordship.
Okay.
Okay.
Thank you, your lordship. My lord, I beg to mention IA in CRP for listing.
When?
Any date.
On 27th.
27th November. Oblige me. May I please your lordship, I beg to mention IA civil, my lord, for listing, my lord, on 20 November.
20?
Yes, 20.
Okay.
Okay, Lordship.
No, so yes. For orders.
May I please your lordship, pray for listing a pending intest case, lordship.
When?
Lordship, any day,
Under which column?
hearing.
Hearing. December.
Hearing in the month of December.
Lordship, difficulty is that lordship, I am appearing of the respondent and interim protection is there, lordship.
Oh, definitely it will be there.
Lordship,
Definitely protection will be there.
On 10th. 10 December.
That is the lordship. So I beg to mention for listing RSA lordship.
When?
Next week, any date, motion matter.
Motion.
Motion matter,
25th.
25th. Motion.
Item for top of the list, item 1 and 2.
May I please? Lordship, in this case, I pray for adjournment, lordship. Mr. GP Homik is engaged in the case. He is not well, lordship.
So this is going on for several months together, perhaps.
Date may be fixed, lordship,
Hmm?
because we have already informed the client to take back the file. No instruction has been received from them. And also, we need some more time to some instruction. Lordship.
Yes, madam?
Lordship.
Date may be fixed, lordship.
January.
After 2 weeks.
The matter was not listed for several years also.
Yes, lordship. That's right. The long pending case. We have to take some instruction from the client. Lordship. We have already informed them to return back the file.
Okay. Heard Miss, Madam
F. Ahmed.
F. Ahmed, Learned Counsel for the appellant, and Mr.
D. Kolita, on appearing
D.
on behalf of
Kolita,
GP
Learned
Bhowmik.
Counsel appearing on behalf of Mr. G.P. Bhowmik,
Yeah.
Learned Counsel for the respondent. Mr. Kolita submits that Mr. G.P. Bhowmik, the leading counsel for the respondent, is unwell. And besides, the respondents need up-to-date instruction from the respondents. Accordingly, a pair is being made to adjourn the case 1 week.
Also, on it.
1 week. Pair is allowed. Is the matter on
28 November,
28 November.
20
28.
28.
Public.
For motion, item number 3.
Here, please, your lordship, as per order dated 6/11/24, yesterday I have filed an additional affidavit, lordship, and same is not tagged with the case record.
How will you call it?
Lordship, it too kindly.
Ah,
Oblige, lordship.
Item number 4 for orders.
In this case, steps upon the remaining respondents have been already been taken. So let this matter be taken up for admission.
is that taken or whether you are for the respondents?
I am for a respondent, my lord.
All the
But,
respondents.
they've already been served copy by remaining governing bodies. Remaining respondent number
my
4
lord.
to
1 and 2, my lord.
1 and 2. And remaining all the respondents, have taken.
You are for respondent number
1 and 2, my lord.
1 and 2.
And he can represent also these governing bodies of colleges also.
No, no,
Because-
no.
How
Cover-
how he can represent?
Because these bodies of colleges are governed under the Department of Education, madam.
Yes, can you?
No, no, my lord. We don't represent the governing bodies, my lord.
Mr. Kosik, you are for?
Madam, I'm not in this.
Not in this case. Okay. Heard Mr. A. Paul, Learned Counsel for the petitioner, applicant, and also heard Mr.
That's my lord.
S. Das, Learned Counsel for the respondent number 1 and 2.
Standing counsel, Harry Dixon, my lord.
Respondent number 1 and 2.
1 and 2.
Standing counsel for the respondent number 1 and 2. When you have taken a step,
That I forget, that is not reflected in the order sheet. After 1 week of last proceeding of this honorable court. So far as now, we go.
office note dated 19/9/2024 indicates that step upon the respondent number 3 to 20 have already been taken, but no report has been received till date. No service report has been received till date. So lays the matter after 2 weeks awaiting service report upon respondent number 3 to 20.
And in the meantime, they have to file their response also. As per last order.
The learned standing counsel for the respondent number 1 and 2 submits that he will file affidavit in opposition here in this petition. And price for granting him some time, here is allowed. This is the matter for 2 weeks.
Lordship will kindly fix it because it is a petition for granting stay of the input selection. So considering the urgency.
on 29th.
What?
29 November.
Publish. Okay.
For hearing. Item number 5. Pattern matter.
Only this matter will be passed for time being also.
Why?
My senior will be appearing in this matter also.
Who is your senior?
Mr. J. Sutia also.
There?
J. Sutia.
Okay.
So sometime.
Item number 6.
My senior is appearing in other court.
Who is your senior?
M.A. sir.
Pardon?
M.A. sir.
MS?
Ahmed.
And let me start, in the meantime, they will come.
Yes, we can.
Let me, you can proceed, because I'll take some time. I'm for the appeal is by the defendants
Hmm.
in this suit. And the trial court.
You were the defendant in the trial court.
Well, the trial court initially
Hmm.
dismissed the suit on 19/12/2008. Then appeal was taken, but the appellate court by judgment in order dated 31/3/2010
Hmm.
allowed the appeal and set aside the decree passed by the trial court,
Hmm.
and then remanded the matter by framing one additional issue
Hmm.
in respect of adverse possession and recasting issue number 4 with regard to challenge to the order of nutrition. And then the matter went to the trial court. Trial court again dismissed the suit on 4/2/2011.
Hmm.
Then appeal was taken on 3rd of April 2012. The appeal was allowed and the suit was decreed.
Hmm.
Again, then the present regular second appeal has been filed.
Hmm.
I've annexed all these documents, but then the judgment of the trial court, my lord,
Hmm.
at page 60 is the judgment passed after remand,
60.
my lord.
Yes.
My lord, please kindly see at page 63.
Hmm.
The issues are there. Issue number 1 is a regular issue of cause of action. 2 is about the bar arising from the provisions of the Assam Land and Revenue Regulation. 3 is regarding the right of the interest. Then 4 is regarding the whether the mutation order details and so past is illegal, etc.
Hmm.
5 is regarding the entitlement of the plaintiff for caste possession.
Hmm. So on what ground the trial court has dismissed the suit?
My lord, trial court has made lordship kindly see, I'm just pointing out, page 63 are the issues. At page 64, my lord, as per the action of the first appellate court,
Hmm.
one additional issue was framed.
Hmm.
That was at page 64, my lord, numbered as 1A.
Hmm.
whether the defendants have been possessing the suit land adversely to the plaintiffs for a statutory period of 12 years, which has the effect of extinguishing the title of the plaintiffs by operation of section 27 of the Limitation Act. This issue was held against the plaintiff. And the second issue was modified issue of issue number 4, whether the mutation order due to transfer passed by the Learned Revenue Authority is illegal and liable to be set aside. Now, Lordship may straightway turn to page 67. The discussion on issue, newly framed issue on adverse possession.
Yes,
Yes.
anything, Mr. Yes,
Lordship, if I am permitted, Lordship, now, my lord, in this case, my lord, the case is based on, my lord, adverse possession, Lordship. My lord, that plea of adverse possession in written statement is required, Lordship, but the copy of the written statement claimed has not been annexed of the, my lord, this name of the bill, Lordship. That is required, Lordship. My lord, it may be directed to be, my lord, furnished, and the date may be fixed for hearing, Lordship. Otherwise, my lord, it will be difficult to, my
My
lord,
lord, page 97 is the copy of the plate, I think.
97. Obviously.
Page 97 is the copy of plate, page 106 is the copy of written statement. These are all there.
97. This is a 97, this is
97 is the copy of plate,
97 is the plain,
my lord.
yes.
And 106 is the copy of written statement.
and 106.
Yes, these are there.
I'm sorry, Lordship. I'm not on to the.
Yes, go on.
My lord. So what I was pointing out at page 67, the trial court discussed the newly framed issue, that is issue number 1 here regarding adverse possession. This issue, my lord, I'll read this issue. This issue has been ultimately decided at page 71. Page 71, my lord. The very second paragraph. From the above discussion and decision, I am of the opinion that defendants have possessed the suit land adversely to the plaintiffs for a statutory period of 12 years, which has the effect of extinguishing the title of the plaintiffs by the operation of section 27 of the Limitation Act. Thus, this issue is decided in affirmative and in favor of the defendants. So, suit was held to be barred by limitation, as well as the defendant has acquired title by adverse possession.
Adverse policy,
My lord.
yes.
This is the prime issue, my lord.
Hmm.
Now, what has happened, my lord? The first appellate court has reversed this finding, and that finding your lord will find from page 85 onwards.
Yes.
And after a long discussion, my lord, ultimately the court has reversed the finding, which your lord will find at page 91. Page 91.
Yes.
At the bottom, my lord, you said like this. As such, the finding of learned trial court needs interference, which I do accordingly. This issue is answered against the defendant. So this finding of the learned trial court has been reversed. This is the position so far of the learned courts below are concerned. My lord, in this case, my lord, I'll read from the judgment of the first appellate court. I'm just giving the gist of what is the case and what is the point I'm arguing. Plaintiff filed the suit claiming title over the land and also recovery of possession. Defendant entered appearance, and the plaintiff's submission was averment in the plaintiff is that they have filed a suit in 2006. They say that in 2006, without indicating the date, that 2006 they have been dispossessed. It's a suit of 2006, man. I'll read the plain. Their case is that they have been disposed in 2006, and that is why they have filed the suit for declaration of title and recovery of possession. But then in the plaint itself, they admit that way back in 1975, there was a mutation of the land minor in favor of the defendant. That is their case. Short case is this. They have written so many things, but this is the, in nutshell, my lord, this is their stand.
In the plaintiff admitted about mutation of the land in
favor of the defendant, and after original father of the defendant, and after the death of their father, in the name of the defendant, subsequently again mutated up on the ground that he is the legal heir.
And on what basis this mutation was done? And
Mutation
in which year it was done? Mutation?
1975. And in fact, my lord, in the prayer,
Why mutation was done?
that is why they have simply said there was a mutation. They say it was illegally done. But the defendant, my lord, may kindly see one thing. They have in the prayer, they have also prayed that the mutation that was done in favor of the predecessor of the defendant is also illegal. Now, so far as the defendant is concerned, my lord, defendant has entered appearance and taken a plea that at the time in the year 75, the value of the land was very less. He lordship is aware under the Transfer of Property Act, if the value of the land is more than 100, then a registered document is necessary for the purpose of transfer of title. So the stand taken by the defendant in the written statement is that at that time the value of the land was very less and it was only 90 rupees. So there was an oral transfer of the land, and based on that, the mutation was granted by the revenue authority. But and so far as possession is concerned, my lord, they have taken a specific plea that right from the day there was a oral sale in favor of the predecessor of the defendant, they were possessing the land, and they have been possessing the land till the time of the filing of the suit. And in fact, they are still possessing the land. That is their stand. Accordingly, they say that they have acquired title by adverse possession as well. Because, my lord, the law is very clear that as a defendant, my lord, he can always take a contradictory stand, but plaintiff cannot. So he has taken a stand that by adverse possession, he has acquired title. Now, initially, when the suit was dismissed and appeal was preferred, considering the plea taken by the defendant, my lord, the First Appellate Court remanded the matter to the trial court by framing an additional issue with regard to claim of adverse possession by the defendant. So that issue was numbered as issue number 1A. That has now been initially decided in favor of the defendant by the trial court, and the suit was dismissed, holding that the defendant has acquired title. That finding has been reversed. Well, we are in second appeal now.
What is the substantial question of
My lord, Order. Well, possibly substantial question of law is only the first substantial question law suggested by the appellant, whether the learned court of appeal will be justified in reversing the judgment and decree of the learned trial court and holding that the defendants have failed to prove the question of extinguishment of title of the plaintiffs under section 27 of the Limitation Act, wherein PW1 has admitted that the defendant has continuous possession of the suit land from 1975, which requires interference under section 100 of the Code of Civil Procedure. My lord, my submission will be, apart from this question, another question may arise, subject to your lordship consideration, madam. When in the plaintiff has clearly prayed for a relief of quashing or setting aside the order of mutation granted in favor of defendant, possibly, my lord, state or the authority which granted the mutation is also a necessary party. And in the absence of the state or the officer who granted such mutation, this suit will be bad also on the ground of non-gender of necessary party, going by the plaintiff itself. This will be my additional submission. Other than this, my lord, when I read the judgment, I am just indicating what has happened here. In course of trial, the defendant also could not prove, this is the finding of the first appellate court. Defendant also could not prove that there was a oral sale and the value was 90 rupees. In fact, the plaintiff in the second round of evidence, my lord, after the remand, has produced and proved a document of a sale of an adjacent plot of land, which has shown that the value of the land is at least 600 rupees per bigha. 600 rupees. That being the position, the first appellate court has held, if it is of a value of 600 of an adjacent plot of land.
In which year?
Almost same year. Now the finding of the first appellate court is, although no such plea was taken in the plea, that since the value of the adjacent plot of land is 600, so the value of this suit land cannot be rupees 90. As a result,
600 per bigha or per katha?
600 per katha. So, a finding of the first appellate court is the value of the land which the defendant said is rupees 90 only is not correct. My submission here will be, my lord, that if the value assuming is more than 100 and registered sale deed is necessary, and if there is no registered sale deed, then the initial entry of the defendant is admittedly through an illegal document, because in course of trial, my lord, defendant also subsequently tried to prove one document saying that there is an unregistered sale deed. Now, if the value of the land is more than rupees 100 and there is no valid document, or the document which has been proved to be a sale is a illegal document, not admissible in law, then his initial entry itself is illegal. Then from the day one, his possession being adverse, and he having resided there till the date of, my lord, filing of the suit, in fact, they are still possessing, their children are still possessing, that is an admitted fact, I saw from the evidence of the PW1, my lord. Then the question of adverse possession will automatically come, because the Supreme Court has made it very clear since 1951 itself. If a person is occupying or possessing a plot of land where his initial entry was either through an illegal document or as a trespasser, then his possession from the day one is that of a adverse possession. And if he has openly and continuously, without any interruption, stayed there or possessed the land for more than 12 years, he acquires the right of adverse possession. So that will be my argument. Well, I'll first read the finding on this issue by the tribe. At page 67 of the finding.
Yes.
Issue number 1A. This issue relates to the factum whether defendants have been possessing the suit land adversely to the plaintiff for a statutory period of 12 years, which has the effect of extinguishing the title of the plaintiffs by operation of Section 27 of the Limitation Act. The defendants plead that late Nur Muhammad had sold away his landed property measuring 1 bigha, 1 katta of land covered by so-and-so and 1 katta, 115 acres covered by Dag number so-and-so to Ahmed Ali orally in the year 1975 and gave possession of the same. And thereafter, Ahmed Ali had mutated in his name over to purchase land on 13/3/1975. And since then, the family members of Ahmed Ali had been possessing the said land too. So there is no possession of the legal heir of late Nur Muhammad. After the death of Ahmed Ali, the name of Nur Islam was mutated over the said land. And I'm just clarifying here. Nur, in the above sentence, it says, and thereafter Ahmed Ali had mutated his name. Ahmed Ali is the defendant, defendant's predecessor. After the death of Ahmed Ali, the name of Nurul Islam was mutated over the said land. And now, after partition among the brothers of Ahmed Ali, the said land falls in the share of Gumar Ali and Tariq Hussain, and accordingly, the land covered by Dag number 148 falls in the share of Gumar Ali. And after the death of defendant number 2 and 3, were in possession of the land, even though their names were not mutated. To substantiate this plea, the defendant's side had examined DW1 Nurul Islam, who in his evidence on affidavit has reiterated the same and narrated in their written statement, but at the same time also exhibited one unregistered sale deed of Exhibit A, from which it reveals that suit land was sold away by legal heirs of late Nur Muhammad, which is totally out of pleadings of the defendants, and so the same cannot be accepted, trusted at this moment. But DW1 during his course of cross-examination has reiterated that they were in possession of the land since 1975, denied of dispossession of the plaintiffs from the suit land. At the same time, DW2 Ahmed Ali has also corroborated DW1 by saying in his evidence that the defendant Nurul Islam had not dispossessed the plaintiffs from the suit land and that he was present at the time of the agreement of sale in between both the parties, and he was also one of the witnesses of Kacha sale deeds executed for the suit land. And this DW2 at the time of further cross-examination after the case was remanded has stated that suit land was sold away by Rashid Ali, the son of late Nur Muhammad and Ahmed Ali, and had purchased the same, and thereafter the name of Ahmed Ali was mutated over the purchased lands. On the other hand, DW3 Abdul Mannan has stated that at present he is in possession of the suit land and along with Abdul Khalek. And this fact is also corroborated from the report of my predecessor who visited the suit land for local inspection. Moreover, PW2 Mutlab Ali and PW3 Nazuddin had also admitted that Abdul Mannan and Abdul Khalek is in possession of the suit land by constructing their dwelling house. These are defendants, my lord. On perusal of Exhibit 1, the certified copy of Jamabandi of the suit land, it reveals that name of Ahmed Ali was mutated over the land covered by Dag number 148 as legal heir of late Nur Muhammad Mahmud, and there is no mutation over the land covered by Dag number 149. Against the names of all the legal heirs of Nur Muhammad are mutated over the land covered by Dag number 149 and 150 in place of Nur Muhammad. So from the above, it shows that Ahmed Ali's name was mutated as legal heir of Nur Muhammad, even though said Ahmed Ali was not really related to Nur Muhammad. From this, it shows that mutation order passed in favor of Ahmed Ali is illegal. The plaintiff side in support of their case while PW1 was examined. This PW1 during his course of cross-examination has stated that he started living Kirkira village after 5 years of death of his father, and at the time of death of his father, he was 15 years old. He further stated that his mother and elder brother Rashid had died at village Kirkira, and this PW1 has denied the fact that Suit land was sold away by his father in favor of Ahmed Ali in the year 1975. Again, PW2 and 3 during their cross-examination had confirmed that they do not know if late Nur Muhammad had sold away the Suit land in favor of Ahmed Ali in the year 1975. So, from the evidence of PWs, it is not established the fact that they have been dispossessed by defendants. Moreover, it is established that Abdul Mannan and Abdul Khalek is in possession of the Suit land, and PWs could not say how they have entered into the Suit land. This is the important element. At the same time, the age of PW1, Forman Ali, was shown as 55 years old in this affidavit, and if it is true, then his evidence to the effect that he was 15 years old at the time of his death of his father, and 5 years of and after 5 years of death of his father, they moved to village Kirkira and stayed there along with other family members and thereon had expired. Nothing matter. So from this, it shows that defendants are in possession of the Suit land for about 55 years, and during this period, the plaintiffs have not raised any objection in possessing the Suit land by the defendants. This finding is very important, madam. This is a clear finding by the First Appeal Court itself. 55 years we are there. As your lordship has seen, madam. So from this, it shows that the defendants are in possession of the Suit land for about 55 years. And during this period, the plaintiffs have not raised any objection in possessing the Suit land by the defendants. Therefore, from this, it reveals that the defendants are in possession of the Suit land continuously, and the possession were exercised as a right for a period of excess of statutory period. I'm sorry, man, I'm reading the finding of the trial court. Moreover, the defendants were not in possession of the Suit land without a claim of right over it, and they very much knew that they possessed the land of which the original owner was the predecessor interest of the plaintiffs. Furthermore, the defendants entered upon the Suit land as owner, which is an assertion of a hostile title. From the above discussion and decision, I am of the opinion that defendants have possessed the Suit land adversely to the plaintiffs for a statutory period of 12 years, which has the effect of extinguishing the title of the plaintiffs by the operation of Section 27 of the Limitation Act. Thus, this issue is decided in affirmative and in favor of the defendants. She is based on the finding on issue number 1, and that we need not read, madam. Now, let me take your lordship to the finding of the First Appellate Court on this issue. Page 85. Page 85.
Yes.
Bottom, paragraph 19. Before proceeding further, it may be noted here that as per the order of this court, while remanding TA number so-and-so, this court has directed the learned trial court to frame an additional issue as to whether the defendants have possessing the Suit land adversely to the plaintiff for a statutory period of 12 years, which has the effect of extinguishing title of the plaintiff by operation in Section 27 of the Limitation Act. Learned trial court, after getting back the record, while ordered it so framed the additional issue as above, has taken up the said additional issue as issue number 1A by keeping the issue number 3 intact. This issue is the crux of the suit, and hence the same is taken up before other issues. The defendant side in their written statement at paragraph 14A under the head Real Facts has admitted that the original patadar Nur Mahmud was the owner for the plot of land measuring so and so and so and so. In those days, the value of the suit land was too low, and again, against a petty consideration of ₹90, Said Nur Muhammad transferred the suit land to Ahmed Ali, son of Muhammad Ali Orli, and put Ahmed Ali in exclusive possession of the land, and thereafter mutated the land in favor of Ahmed Ali to mark the transfer. Such transfer and mutation have vividly been described in the Jamabandi of PP number so as per the order dated 13/3/1975 of the learned SDC, Barpeta. Since then, the family members of Ahmed Ali have been possessing the land, and no portion of the suit land was possessed by legal heirs of Nur Mahmud. After the death of Ahmed Ali, name of defendant number 1 was inserted by order dated 30th March 1995. In paragraph 14D of WS, it has been pleaded that since 13/3/75 till the date of submission of the suit above, more than 30 years have been passed, and as such, the provisions of Section 90 of the Evidence Act and Section 27 of the Limitation Act will be applicable. Hence, plaintiffs cannot raise any demand regarding the suit property. It is also pleaded that subsequently the said land of Dag number 148 fell in the share of brother of Ahmed Ali, namely Gomar Ali, and on their death, their son Abdul Mannan and Abdul Khalek are possessing the said land since 1980. In view of the above pleadings, the defendants have denied the allegation of disposition brought by the plaintiffs. On the cursory reading of WS paragraph, particularly paragraph 14 of the WS, as noted above, the defendants nowhere in the specific words claim that they are possessing the land adversely against the interest of the plaintiffs, or the other minimum requirement of adverse possession, that is free neck by neck clan and neck vicario, that is possession of the land openly, notoriously, and continuously. However, in view of ratio cited as case law of Raju Saha Supra, as relied upon by the learned advocate for the defense respondents, might be as a matter of emergent precaution, my learned predecessor in office has remanded the suit by claiming the above additional issue with the direction to consider this aspect. In course of appeal hearing, learned advocate for the appellants has argued that though the issue has been framed, yet as the defendants have claimed to have purchased the land on the strength of 90 rupees and delivery of possession and getting mutation, they cannot be allowed to take the shelter of possession of land adversely, and the defendant can only succeed if he proves the purchase by better evidence than plaintiff. It is also argued that the taking the plea of lawful purchase in the one hand and on the other hand claiming their possession adversely, both the pleadings are mutually destructive and hence cannot be allowed to stand simultaneously. I found sufficient force in the submission of learned counsel for the appellant side. On the Supreme Court, in the reported case of so-and-so held, where possession can be referred to a lawful title, it will not be considered to be adverse. The reason being that a person whose possession can be referred to a lawful title will not be permitted to show that his possession was hostile to another's title. One who holds possession on behalf of another does not by mere denial of that other's title make his possession adverse so as to give himself the benefit of the statute of limitation. Therefore, a person who enters into possession having a lawful title cannot divest another of that title by pretending that he had no title at all. The above ratio clearly indicates that if a party claiming acquiring lawful title, they are debarred from taking the plea of adverse possession on the basis of their long possession. The defendant shall have to be successful on his pleadings of acquiring lawful title, and in the event of his failure, he has to go. Thus, if a defendant takes the plea of purchasing land lawfully, he cannot be allowed to raise the plea of adverse possession. Most probably, for that reason, the defendants at paragraph 14 of their written statement simply claim their long possession since 1975 without asserting the plea of notorious and hostile possession against the interest of the plaintiffs. This plea has been raised in argument stage by relying upon reported case of Raju Saha. This is a case of dishonorable court, my lord, where it has been held as follows. I have carefully considered the arguments advanced by the learned counsel for the parties. I have also carefully gone through the pleadings of the parties. From the pleadings in the objection to the counterclaim as pointed out by the learned counsel for the respondents and as quoted above, it is more than convincing that although no term like adverse possession, this is important, no term like adverse possession has been expressly employed, all the facts necessary to constitute adverse possession have been set out clearly and unambiguously therein, and it is so implicit that the appellants were not taken by surprise, thereby leaving any scope to take an objection that the question of adverse possession cannot be raised or dealt with in the second appeal. No doubt the courts below, for reasons best known to them only, did not frame a definite issue on the question of adverse possession, but nevertheless, the respondent plaintiff led cogent and convincing evidence to establish their claim of adverse possession over the suit land. The lower courts below duly considered the said evidence and came to a finding that the possession of the suit land by a plaintiff continued uninterrupted since the year 1964 and against the true owner, if any, and accordingly they acquired the right of adverse possession against the true owner. After all, the question of adverse possession is basically a question of fact, and the same is to be proved by evidence. This fact of adverse possession having been proved by adducing sufficient evidence, the same can be interfered with in the second appeal. These facts of this case are almost similar to our facts. The above ratio of the Honorable Guwahati High Court is not applicable in the present case in hand because the defendant side in the written statement has taken the plea of lawful purchase of the suit land and did not even impliedly take the plea of adverse possession by asserting the ingredients of long possession openly with hostile attitude. Having taken into note of above legal aspects, let me move to the evidence on record as to the nature of possession of the defendant's side. Let me look at the defendant's evidence as to whether they have been able to prove their plea of purchasing the suit land from Nur Muhammad by paying ₹90. It may be noted here that the sale of immovable property below ₹100 need not be made by registered instrument. It means that sale of suit land at ₹90, if proved, has given a valid title to the purchaser. The first ground in the support of their purchase the defendants have taken is granting of mutation in favor of Ahmad Ali. On going through the certified copy of Jamabandi as proved by both sides, it is clear that name of Ahmad Ali, son of Muhammad Ali, the predecessor of the defendant number 1, was mutated as sharer of the Nur Muhammad and not as purchaser. The said mutation did not reflect the transfer of land by way of sale at ₹90. The mutation entries as claimed by the defendant side not support the claim of the plaintiff. Claim of the sale of the land by Nur Muhammad to Ahmed Ali. During evidence, defendants have examined defendant number 1, Nurul Islam as DW1, 1 Abdul Mannan, son of Umar Ali as DW2, and 1 Abdul Mutlab as DW3. In their examination in chief, they have asserted the fact of transferring the land at ₹90. However, DW1 in his prosecution stated that he is not sure as to whether the contents of affidavit are in consonance with the pleadings of his WS. He further admitted that he has no knowledge regarding transfer of the land at consideration of ₹90. He further admitted that he has submitted an unregistered sale deed showing sale of the suit land, which was marked as Exhibit A by him. He was not present at the time of execution of Exhibit A. On going through Exhibit A, it appears that on 10/3/75, the plaintiff and on behalf of the plaintiff number 1, Forman Ali, his mother, Sarifannesa, transferred the suit land, transferring 1 biga 1 kata at a price of ₹600. This is what I was saying, madam. 600 in favor of Ahmed Ali, the father of defendant number 1. Learned trial court, while discussing the evidence, has rejected the Exhibit A and refused to rely on the same on the ground that in the WS they have not taken the plea of executing Exhibit A by the plaintiff side. It is true that in the way W no such plea has been taken, but when the defendants have produced this document which contradicts their claim of purchasing the land at a price of ₹90, it cannot be overlooked. The existence of Exhibit A shows that the plea taken by defendant side of purchasing the land at ₹90 is false and it damages the credibility of the evidence of the defendant side. So far, it relates to their claim of purchasing the suit land at ₹90. Apart from this, the plaintiff side have also produced one registered sale deed by Exhibit B showing sale of 4 bigas of land of Dag number 147 at a price of ₹2,000, which was executed by plaintiff on 7/2/1975. Exhibit A was also executed on 10/3/75. It is in the evidence that the above 4 bigas of land is contiguous to the suit land. The existence of Exhibit B thus shows that in the year 1975, the value of the land at ₹500 per biga, and thus this document also cast shadow on the claim of defendant side that the suit land was sold at a price of ₹90. Normally, a civil court should not bother about the consideration amount of transfer if not challenged by the parties. But in this case, the plaintiff side has totally denied of transferring the suit land in favor of defendants. Defendants, to get their claim of purchase legitimized, has taken the plea of purchasing the land at ₹90 without any direct evidence of such purchase. Hence, it becomes necessary to consider the amount of consideration as an evidence to decide the genuineness of the claim of sale. DW2 Abdul Mannan, whose cross-examination has been recorded as DW3, has stated that He did not know to read and write English, and hence he cannot say what was written in the affidavit for examination in chief. He also admitted that the land was given to them by Ahmed Ali and their names have not mutated. DW5 Ahmad Ali in his cross-examination admitted that Rashid Ali sold the suit land by way of Chita mutation and further admitted that Ahmed Ali was not a relative of Nur Muhammad. On going through the record, it appears that Rashid Ali has no mutation on the date of LS sale and he has no absolute right to sell the scheduled land by Chita mutation. Transferring of land by Chita mutation is not recognized by TP Act. From the above oral and documentary evidence, it is clear that defendants failed to prove their claim of purchasing the suit land at rupees 90 from the plaintiffs, and thus they have not acquired any title over the same. Now, as the defendants have failed to prove their lawful purchase and having no express or implied pleading of possessing the land openly with hostile attitude, this court, on its shown, cannot make out a case of long possession into a case of adverse possession. Even then, as an issue was framed, let me consider the fact of possession over the suit land. Plaintiff side in their evidence and their pleadings claim that on 16/10/2005, the defendants asked the plaintiff to vacate the suit land and also dispossess them on the same day. The above fact has been reiterated by the plaintiffs in their affidavit for evidence submitted on 19/7/2010. During cross-examination, PW1 Forman Ali remained firm on the point of disposition by the defendants. He admitted that about 4 years back, he went to Kirkira Reserve, and in the year 2005, the defendant forcefully dispossessed him from the suit land. Though he cannot say about the English date, etc., but he asserted that at the time of disposition, he has his house on the suit land. PW2 Abdul Matlab in his cross-examination reiterated that since 2005, plaintiffs are in possession of the suit land on 16/10/2005. Defendants took forcible possession over the suit land. Now PW3 Nazimuddin, though in his evidence could not say about the differences between 75 and 2005, but stated that disposition took place in winter days. He further stated that over the land presently possessing by the defendant, the plaintiffs have had his residential houses. During cross-examination of PW1, PW2, and PW3, not a single suggestion was given against the claim of the plaintiff that the defendant dispossessed them in the year 2005. Evidence of the plaintiff side clearly proved the fact that plaintiffs were dispossessed in the year 2005. The evidence of plaintiff remains unshaken and reliable on the point of their possession till 2005. And I'll show from the evidence of PW1 how these findings are perverse because PW1 has said something else in the evidence, particularly in cross-examination. I'll read just 2-3 lines. Next page. Hence, on this count also, the defendant side have failed to show that they have possessed the suit land since 1975, uninterruptedly, continuously for more than 12 years. From the above discussion, it is clear that defendant have failed both on the counts to establish their claim. Law is well settled that mutation in revenue record neither extinguishes the title nor creates any title. Every mutation must be backed by lawful title. Honorable Supreme Court of India in the case of reported Gitarani versus Paul Svensson held that in the face of clear pleadings and evidence on record, the High Court was wrong in reaching the conclusion that there was no pleadings and evidence regarding disposition. Even otherwise, in the face of the finding of the courts below that the appellant plaintiff had proved her title, it was not necessary for the High Court to go into the question of ascertaining the date of disposition. This is not very relevant. Next paragraph 31. In the case of Indira versus Arumugam, when the suit is based on title for possession, once the title is established on the basis of relevant documents and other evidence, unless the defendant proves the adverse possession for the prescribed period, the plaintiff cannot be non-suited. In the present case in hand, it is admitted that Nur Mahmud was the original patadar for the suit land measuring 1 biga 1 kata, and plaintiffs are legal heirs of Said Nur Mahmud. As Said Nur Mahmud or his legal heirs has not transferred their title over the suit land in favor of Ahmad Ali, the same is subsisting in favor of plaintiff. As the defendants have failed to prove their plea of purchase, and as they are not legally allowed to take the plea of adverse possession, which otherwise also they have failed to prove, there is no question of extinguishment of title by operation of Section 27 of the Limitation Act. While discussing this above issue, learned trial court has gone wrong and misled the evidence and failed to apply the law in proper perspective. Learned trial court, while deciding this issue, has overlooked the oral evidence of the plaintiff side and wrongly rejected the exhibit A, which is a proof of false plea on the part of the defendants. As such, the finding of the learned trial court needs interference, which I would do it accordingly. This is answered against the defendant side. This is the finding. My lord, lordship has seen, my lord. The first appellate court has proceeded on the basis as if in issue number 1A, the court is called upon to decide whether there was a valid sale or not. And that is why there are discussions that no, there was no sale deed, value of the land was more than 100, and an adjacent plot of land was shown to have been sold at a price of 600, and another plot at a price of 2,000. So sale deed was necessary, so they have not been able to prove their title. While the court has confused with the question of the issue frame. Issue is that whether they have acquired title by adverse possession. For that, my lord, the defendant's claim is very simple. Their claim is that, see, my initial entry mutation is there in the year 1975. Since then, I have been openly residing there, you are not there. Plaintiff has taken a, my lord, plea of coming to possession.
No, is it not permissible to take both the plea as taken by the defendant?
Defendant can take, plaintiff cannot mind.
Mm.
Then I'll show one judgment of the Supreme Court.
Mm.
Plaintiff cannot take contradictory plea,
Mm.
but the defendant can take contradictory defense.
Mm. No,
So
but the first appellate court in this judgment held that he cannot take both the plea.
Plaintiff.
No, this
Defendant.
defendant, yes.
Yes. Well, that is why when the first appellate court ultimately the decree was in my favor.
Mm.
So I did not have the need to file an appeal.
Mm.
They have filed an appeal. Now the appellate court judgment has marred the first appellate court judgment. So we have to challenge the first appellate court judgment. But the issue was very simple. Whether issue was framed by the first appellate court in the first round, remanding the matter to the trial court, that whether the defendants have acquired title by adverse possession. Trial court has decided the issue in favor of the defendant against the plaintiff. So the suit was dismissed. On appeal, the appellate court has reversed the finding. Now, while reversing the finding, as your lordship has seen, the discussions are that whether the defendant has been able to prove their title by virtue of the claim they have made that at a price of ₹90 orally they have purchased. Court is saying no, they have not.
Issue relates to adverse possession.
Adverse possession, not as to whether the defendant has acquired title by purchase. And another aspect, my lord will see, ultimately the first appellate court on the one hand is saying that they have not been able to prove their title. On the other, the first appellate court is trying to find out whether there was any valid transfer of the sale in favor of them. Now, defendant is not now saying that there has been a valid transfer. From the evidence, it is absolutely clear that oral sale they could not prove. Exhibit A, they have brought, exhibit B, other side has brought. Ultimately, in the ultimate analysis, the first appellate court's finding is there is no valid document to show that there is a transfer of title. Is that, my lord, am I, my lord, clear? Defendant has not acquired title through a valid document. That is the finding of the first appellate court. Now, the question remains, if from day one, without any valid title, I am possessing the land. That was the question, my lord. That is why possibly I'll first of all pray that the entire judgment may be set aside and the decree passed by the trial court may be affirmed. But if your lordship finds that no further discussion or further consideration of the evidence is necessary, your lordship may explore the possibility of remanding the matter again. Because my submission is, my lord, first appellate court has confused the whole issue. Issue was not as to whether defendant has acquired title by virtue of a document or a
Mm.
transfer, oral transfer.
Mm.
Issue was whether he has acquired title by adverse possession. For that, in the facts of this case, my lord, the discussion should have been that whether his initial entry was through a valid document or valid transfer or not. If not, then whether he has been possessing continuously till the date of filing of the suit.
Mm.
And am I clear, my lord? The examination of the court is when the issue itself is whether the defendant has acquired title by adverse possession, then court has to first see that whether my initial entry into the suit land, whether my initial possession of the suit land is by way of a valid document or not.
Mm.
If it is by a valid document and I am entitled, I am admitting the claim of the defendant, sorry, the plaintiff vendor, then subsequently I cannot change the stand and say that no, I have been possessing adverse to the interest of the vendor. I cannot say because my initial entry is through a valid document. I'll cite some judgment also on this matter.
Mm.
There is a constitutional bench judgment of 1951 Supreme Court itself.
Mm.
Then subsequent judgments are there. If my initial entry is valid, but there is a difference matter. If my initial entry is on the basis of an agreement to sell, which says that subsequently the vendor will sell it to me, that means till the time the sale deed is not executed or executed, I am admitting that the vendor has a title because he will execute a sale deed in my favor. Then I cannot put up a defense that see I am possessing the land adverse to the interest of the vendor. But if it is an outright sale on the first day, and the vendor says that from today there is a divestiture, well, Supreme Court says there is a divestiture. He has divested himself of all his rights over the land. From that day, he is not claiming any right over the plot of land. That means from that day, he accepts that the defendant who is possessing is asserting his title openly and adverse to the interest of the vendor. Then, ultimately, if it is found that he is claiming adverse possession, if it was from the day one, if it is adverse, my lord, then he can say that if 12 years have gone, I am acquired title by adverse possession. But in a valid sale deed, my lord, this cannot happen because I acquire title. But if the initial sale is actually invalid in the eye of law, but the vendor has divested his right. In our case, my lord, pursuant to some document, we say there is a oral. They say no, there was you have made a false document. We again come with another document because 2-3 rounds of evidence was taken, my lord, after the remand. 3 times. I'll come to that, man. We have tried to show that there was a document of unregistered sale deed. They have tried to show that another sale deed was there of an adjacent plot of land of a higher value. And so far as you are concerned, there is no sale deed, valid sale deed. But mutation was there in my favor, my lord. And they have challenged the mutation also. So they know for the last 55 years, as the trial court has held, my lord, last 55 years on the basis of a mutation against the interest and openly, I have been possessing the original, my lord, original person who has been possessing. Then after his death, his legal heirs have been possessing, and it has in this way 55 years have elapsed. Whether it is not a case of adverse possession, my lord. I create some document, maybe invalid. In this case, it is absolutely invalid. There is no registered sale deed, my lord. That is the clear finding of the first report. There was no valid sale deed. So my initial entry is illegal. There was a mutation. Mutation was also illegal because in the mutation, ultimately, from the evidence, it has been shown that mutation was granted on the basis of right acquired as a legal heir. Uttaradhikari Putri. So I was not, it is clear that I was not a legal heir. Court have come to a finding that he is not a relative. He is not related. Noor Mahmood was not related to Ahmed Ali. So a third person enters into a land, possesses for 55 years, and there is a mutation in his name, which are totally against the vendor. The vendor is aware, 55 years they do not do, they allow them to go to the next generation, third generation, now third generation are occupying. Now, this for generation wise, if they are occupying openly and they have not claimed, whether it will not be a case of adverse possession, that is the question. So far as possession is concerned, my lord, there is one more aspect is there, my lord. So far as possession is concerned, the plaintiff has filed a suit because they have filed a suit after 55 years. So in order to save the limitation, my lord, they have taken a plea that in the year 2005, they acquired the possession. And on 16th of October 2005, they have given a specific date, my lord. On 16th of October 2005, they were dispossessed by the defendants, and that is why they have filed the suit now. But it has been clearly, my lord, stated by them that they came into possession of the land in 2005 without indicating any date and without also saying as to why they came into possession of the land in 2005. What happened to the period earlier to that? There is no explanation. Now, I'll show from the evidence of PW1 that 2-3 rounds of recording of evidence was there.
No, now this 12 years,
Well,
you have to count from which date?
from
From
the,
the subsequent disposition?
no,
From the earlier one?
no, from earlier.
Then earlier already 12 years elapsed.
All are already loves. But why I'm saying, my lord, they have framed the suit in such a way that from 2005 I was there. October 2005 I have been dispossessed and I filed the suit in 2006. Where is the question of 12 years? Because I have to show 12 years have elapsed in between. So that is why they have taken a plea that 2005 we came in possession. 2005 October 16, defendants have dispossessed us. That is why our suit is within time. This is their plea in the plaint. Now, if I can show your lordship, my lord, from the evidence of PW1 itself, that in 2-3 rounds of my lord cross-examination, ultimately he broke. And he has admitted that these persons are there for last 55 years.
Admitted.
Yes. And the learned first appellate court, while reiterating twice that now I am going to consider the case of nature of possession, does not discuss as to who has been in possession for the last 55 years, what are the materials, what is the evidence on record, so as to come to a finding as to whether the plea taken by the plaintiff that they were in possession from 2005 without indicating the date, and October 16 they have been dispossessed. This discussion was not there, number one. No finding, number two. And number three, my lord, this particular evidence has not been considered by the first appellate court. So the finding with regard to possession is on the basis of that particular line itself is very adverse line, perverse line. I'm just showing one line.
Page number?
Hello, it is in evidence of PW1. PW1's evidence was recorded twice, my lord, because there was a remand, there was an amendment. My lord, there is a cross-examination on 13/9/2006.
Cross-examination of PW1.
PW1, Muhammad Farman Ali. Had it been a, my lord, admission by some other person, the matter would have been slightly different. He is the main man. He is the plaintiff, my lord. There is a cross-examination on 13th of September 2006.
13th of September,
my lord,
2006.
my lord, 96, I'm sorry, 2006, my lord, yes.
Yes.
My lord, lordship may kindly see only the last line.
Technique. Yes.
Last sentence, lordship may kindly see. Bibadio mati. Lordship has got my lord. Bibadio mati.
Yes, yes.
বিবাদীয় মাটি গুমৰালি আৰু আলেক মান্নান সকলে দখল কৰি খাই আছে 1975 চনৰ পৰা দখল কৰি খাই আছে. What else is required by law? And I would have, my lord, accepted the finding of the learned first appellate court if this evidence is considered and compared with some other evidence, this evidence is not found to be reliable, then matter would have been different. There is no reference of this evidence, very important and material evidence, my lord, in the entire discussion on issue number 1A. There are other evidence also, my lord. I'm just going straight with this, and there is a requirement of considering this relevant evidence. And in the absence of, my lord, consideration of this evidence, the finding with regard to possession that we have not been able to prove our possession, etc., is perverse. That is why I say, my lord, there is one way of taking all the evidence and pleadings on record, and your lordship taking the trouble of deciding here, or your lordship may subject to your discussion.
Now you tell me, is it possible to arrive at a finding on the basis of the materials available on the record?
It is
No.
possible, my lord. It is possible, but then one aspect is there, my lord. The finding of the learned first appellate court on issue number 1A, my humble submission before lordship, my lord, subject to lordship's consideration, is that the initial approach of the learned court is wrong. Because approach of the learned court should have been on two aspects, my lord. First, whether the defendants have been possessing the suit land since 1975 or not, by considering other materials, including this material, as to whether the defendants have been able to prove that from the day one of 1975, they have been possessing the suit land till the date of filing of the suit. Even, in fact, my lord, the learned trial court has a recording finding that also has not been considered by the first appellate court, that there was a local inspection. And in the local inspection report is come, we have got a copy of that report also. Report is come that this Alek Pannan, who is admitted to be a possession, Alek Pannan is possessing, Gumorali, they are possessing. They are the legal heirs of the person initially took possession. They are in possession. The local inspection also report says. Now, if the defendants and their legal heirs have been possessing the land since 1975, so my submission, whether they have been possessing or not, if the first point goes against them, then the second point, there is no necessity of discussing because they are not in possession. And if the first point with regard to possession is decided in favor of the defendant, that yes, they have been possessing for 55 years, the next question will come whether their possession was adverse to the interest of the plaintiff.
Mr. Majumdar,
Madam.
can we take this line isolated from the other part of evidence, other piece of evidence?
Absolutely not, my lord. Absolutely not. Your lordship will have to take into any court recording a finding on possession will take into consideration all the relevant material evidence, including this part. This is a direct and clear evidence, my lord. And I can show your lordship, my lord. Every time the PW1 was cross-examined, he has been improving in his case. Because he knows what is his case. He has been improving his case every time. But lastly, he could not, and he admitted that for the since 1975, they have been possessing. Well, PW1 also stated in his evidence that in the very beginning, when he was about 15 years of age, they have left this village. They've been residing in Kirkiragaon. There was some discussion. So they have the entire family shifted. They have been staying there. They knew that this plot of land is being occupied by the dependents, and they are residing here. Well, I'm not saying that only this evidence has to be taken into consideration, but this evidence cannot be ignored either. Can it be ignored, my lord? This is a clear evidence by PW1, who is the plaintiff. He is making a clear and unambiguous statement that, see, for the last 75 years, they are occupying here. Now, for recording a finding as to who has been possessing the land since 1975, this evidence has to be taken into consideration, my lord. Has to be discussed. Maybe based on some other oral evidence, court may say, no, I don't believe it. This is not, because ultimately it's preponderance of probability. This may not be weighing over the other evidence, but there is no discussion on this line. So this part of the evidence has been totally ignored. Thereby the position, the evidence finding on the question of possession, in fact, there is no finding at all. So finding, if any, my lord, is perverse because of this non-consideration of this evidence. And it's, my lord, the lordships are well aware, my lord, any finding recorded by the court below, even if it is a concurrent finding, if it is on the basis of a material which is not admissible in law, or without considering any relevant evidence, it becomes perverse.
Mr. Mozumdar, now you tell me,
Yes.
can sitting in second appeal, this court can re-appreciate this evidence?
Absolutely, my lord. Yes. It's not a question of reappreciating the evidence, my lord. Reappreciating evidence, my lord, is subject to, my lord, correction, my lord, is that an evidence has been considered by the court, a finding has been recorded. Now I want the, in the second appeal, I want your lordship to record a different kind of finding based on the same evidence, giving a different interpretation to the evidence, and saying that kindly reappreciate the evidence. It is not a question of reappreciating the evidence. It's a question of considering the finding of the first appellate court to see whether it is perverse for non-consideration of a relevant evidence. It's not a question of reappreciating evidence. Reappreciation will be the evidence has been taken into consideration, considered, and based on that a finding is recorded. Now I say that kindly revert the finding by interpreting that evidence which has been taken into consideration by the courts below in a different way. That will possibly be subject to consideration.
But there are several judgments of Supreme Court
My lord.
that first appellate court is the last court for
Fact. Last court of it. Yes, ma'am. That I don't dispute the madam. I mean, my only finding is when the Supreme Court has made it very clear that any finding recorded by the court below, if it is perverse, lordship in exercise of power under section 100 of the Civil Procedure Code will always interfere, even if it is concurrent. In our case, when it's not concurrent.
No, it is not concurrent.
Concurrent. And even if it's concurrent, your lordship desires, I can bring these judgments also.
I can also show you one judgment.
My lord.
Okay, after a break.
My lord.
Anything more to submit?
My lord, that is all.
That's all.
My lord. I have got two judgments to show, my lord. Should I?
Yes, you can place it.
This is on Article 64 and 65, adverse position, my lord. Para 8 and 9 are the two paragraphs I am relying on.
Hmm.
Para 8 man.
Hmm.
The division bench noticed that all that the plaintiff has to prove is that he or his predecessor in title was in possession at any time between 1947 and 1959. If
Mm.
between February 11, 1947 and July 17, 1947, the possession of Varada Reddy was possession held on behalf of Dasu Reddy, then it could be held that the plaintiff's predecessor in title had been in possession within 12 years prior to the suit. The division bench held that the transaction of July 10, 1946 was in fact and in law only an oral agreement for sale, and that on the assumption that it was an oral sale, the learned single judge failed to apply the legal position as enunciated in Swenso judgment. They observed that the position as held by Varada Reddy subsequent to July 20, 1946 and before he instituted the suit in 1949 for specific purpose of was in consciousness that it was only possession on behalf of the real owner. Even if the execution of an impartial sale deed on Swenso by Swenso in favor of Swenso is assumed to have altered the complexion of events in any manner, the possession of Varada Reddy from July 46 to July 47 at least was clearly possession held on behalf of Dasu Reddy, the predecessor in interest of the plaintiff. If the plaintiff predecessor had been in possession of the suit property on July 47, that is to say within 12 years prior to the institution of the present suit on Swenso, there can be little doubt that the plaintiff must succeed on the question of possession as well. In this view of the judgment of the learned single was reversed. There is no controversy that the plaintiff has to establish subsisting title by proving possession within 12 years prior to the suit when the plaintiff alleged disposition while in possession of the suit property. The first appellate court as well as the second appellate court proceeded on the basis that plaintiff is not entitled to succeed as possession has not been proved. The concurrent finding that the plaintiff had title in spite of decree for specific performance obtained against him when the decree had not been executed are not assailed by the appellate court. The appellant cannot therefore argue before us on the basis of findings of the earlier suit to which he was not a party as against Swenso. The sole question that has been considered by the High Court is that of subsisting title. We have to consider whether question of law as to character of possession of Varada Reddy Swenso is adverse or only permissive. In the case of an agreement of sale, my lord, from here the discussion starts. In the case of an agreement of sale, the party who obtains possession acknowledges the title of the vendor, even though the agreement for sale may be invalid. It is an acknowledgement and recognition of title of a vendor which excludes the theory of adverse possession. The agreement, if it is agreement to sell, it will be different. The well-settled rule of law is that if a person is in actual possession and has a right to possession under a title involving a due recognition of owner's title, his possession will not be regarded as adverse in law. Even though he claims under another title having regard to the well-recognized policy of law that possession is never considered adverse if it is referable to a lawful title. This is the law, if it is referable to a lawful title. The purchaser who got into possession under an executory contract of sale in a permissible character cannot be heard to contend that his possession was adverse. In the conception of adverse possession, there is an essential and basic difference between a case in which the other party is put in possession of a property by an outright transfer, both the parties stipulating for total divestiture of all rights of the transferor in the property, and in a case in which there is a mere executory agreement of transfer, both parties contemplating a deed of transfer to be executed at a later point of time. In the latter case, the principle of estoppel applies, stopping the transferee from contending that his possession, while the contract remained executory in stage, was his own right and adversely against the transferor. Adverse possession implies that it commenced in wrong and is maintained against the right. This is the line. When the commencement and continuance of possession is legal and proper, referable to a contract, it cannot be adverse. The next paragraph, my lord. In the case of an executory contract of sale where the transfer is put in possession of a property in pursuance of an agreement of sale and where the parties contemplate the execution of a regular registered sale deed in the animus of the purchaser throughout is that he is in possession of the property belonging to the vendor and that the former's title has to be perfected by a duly executed registered deed of sale under which the vendor has to pass on and convey his title. The purchaser possession in such cases is of a derivative character and in clear recognition of and in acknowledgement of the title of the vendor. The position is different in the case where in pursuance of an oral transfer, can you see, oral transfer or a deed of transfer not registered, the owner of the property transferred the property and puts the transfer in possession with the clear animus and on the distinct understanding that from that time onwards, he shall have no right of title to the property. In such a case, the owner of the property does not retain any vestige of right in regard to the property, and his mental attitude towards the property is that it has ceased to belong to him altogether. The transferee, after getting into possession, retains the same with clean animus that he has become absolute owner of the property and in complete negation of the right or title of the transferor. His enjoyment is solely as owner in his right and not derivatively or in recognition of the title of any person. So far as the vendor is concerned, both in mind and actual conduct, there is a total divestiture of all his right, title, and interest in the property. This applies only in case where there is a clear manifestation of the intention of the owner to divest himself of the right of the property. On the other hand, in the case of an executory contract, the possession of the transferee until the date of the registration of the conveyance is permissive or derivative and in law is deemed to be an on behalf of the owner himself. The correctness of the decision in so and so cannot therefore be doubted. So, my lord, if my initial entry is through a valid title, or if it is not valid but an agreement, then till the date I am possessing, I am actually recognizing his right. I am not setting up an adverse title because I am waiting for him to again exercise his right of ownership and execute the sale deed. But if it is a sale, but it is invalid, or maybe oral, but if it is illegal, transferee, so far as transferor is concerned, he is thinking that, see, from today I have given everything to him, I am not exercising my right any longer. And so far as the transfer is concerned, he is asserting all his right over the land, enjoying, occupying, using all the usufruct of the land and to the adverse interest of the vendor. In that case, his possession becomes adverse. But the language is still very clear. It becomes adverse because I am occupying, I am enjoying the property, you are no longer there, you have seen me. You have left this village and left to another Kirkira village. You know that for generations, 55 years, my lord, I am occupying the land, enjoying. Next generation comes, they get their name mutated, they are enjoying. Then third generation comes, they are mutating their name.
No, if it is from the year 1975.
55, man.
No, this admission is from 1975.
Yes, 75, 85, 95, 2006 they filed the suit. 75, 55 years from 75. So, my lord, I am occupying requirements of 12 years. Admission is that I am there for last 55 years. And the manner in which I am possessing, my initial entry is illegal because there is no sale deed. And on the basis of some mutation obtained illegally, I am possessing. This is what the learned First Appellate Court was required to consider.
No, if we count from 1975
My lord,
till the filing of the suit, how can it be 55 years?
my lord,
How can it be 55 years?
not necessary. Only 12 years is necessary.
Yes, No, but that finding of the trial court,
My lord,
that
maybe wrong, maybe wrong. It may not be 50, it may be 54 or 56. What I am saying is, my lord, from the year 1975, they admit that they are not there. And in other part of the evidence, they say that from the age of 15, our whole family shifted to Kirkira village. And since then, the defendants are occupying for generations. 2006, I filed a suit and I take a plea there that see, 2005, I came into possession. 2005, October 16, you dispossess me. And that is why the suit for recovery of possession. Then I take a plea that no, there was an oral sale something in 1975. And in the month of March 1975, there was a mutation in favor of the original predecessor interest. And since then, we have been occupying. Now, what is to be done, my lord? Whereas it's true, my lord, adverse possession law, Supreme Court is very, very clear that courts are very harsh because you are actually depriving a rightful owner from the ownership of the land. So that is why the burden is very high. So, my lord, here, my lord, materials are very clear. From the year 1975, the defendants have been occupying and clearly on the basis of a wrong document. Their initial entry was wrong because there was no valid sale deed. The First Appellate Court has come to a clear finding that see, I have come to a finding that the value of the land is not so low as you are saying, and registration of a document is necessary because the adjacent plot of land has been sold by virtue of a registered sale deed. But in your case, there is none. Instead of recording a finding that you have not acquired title because there is no sale deed, the court should have held that see, so far as you are concerned, your entry is illegal. Because if that finding is recorded, my lord, the court will have to ultimately record a finding that if you have been possessing the land illegally since 1955, you have acquired the title by adverse possession. And the judgment which has been, my lord, quoted one paragraph from our judgment 2019 GLT, my lord, it says that specifically adverse possession word should not be mentioned in the pleading. From the materials on record, if it is found that they have been occupying, they are enjoying the property, adverse to the interest of the plaintiff, adverse possession will come.
Okay, resume after 5 minutes.
Fine. In the second appeal, in exercise of power of section 100, the court will not interfere. And my submission will be, I'll rely on a judgment, my lord. On that line, I have not brought the judgment. Otherwise, my lord, if your finding appears to be perverse, and the entire case rests on that particular finding, the matter will be different in my humble submission. Otherwise, my lord, if in a particular fact is recorded without considering the evidence, and it has got no relation with the ultimate judgment to be delivered, then matter would be different. But here is the case, my lord, on this finding of this fact of possession as to whether for the last since 1975, the who was in possession is a very material issue, my lord. On this finding, the entire judgment will rest. Because for deciding the issue number 1A regarding adverse possession claim of the defendant, two things I have already submitted, my lord, are required as to who was in possession for the last so many years, number one. And number two, whether if the defendant was possessed, if the defendant is found to be not possessing, the matter is different. Then his whole claim falls through. But if the defendant succeeds in showing that he has been possessing since 1975, the next question will be whether his possession was adverse to the interest of the plaintiff. These are the two things. In such circumstances, my lord, in the finding of fact with regard to possession, and my submission will be that judgment will not apply here for the simple reason. In our case, my lord, there is no finding as to who has been in possession, my lord. Lordship has seen, my lord, without taking into consideration this part of the evidence of PW1, which is very material. A finding cannot be recorded. In fact, no finding was recorded as to who is in possession. Court, while discussing issue number 1A, only said whether the defendant has been successful in proving his title. And the court records that no, he hasn't been able to prove his title because there is no valid document. My lord, when there is a claim of adverse possession, he is asserting a fact that I'll show from the written statement, my lord. He is asserting a fact that I am possessing adverse to the interest of the plaintiff. And here is a case where in course of trial, my lord, it is very clear that from day one, he has been possessing, number one. Number two, his initial entry into the land was illegal because these being a, my lord, patta land, there should have been a registered sale deed. The registered sale deed is not there. This is the finding of the first appellate court. My lord, on the judgment which I have referred of 1990 volume 4 SSC, that Achal Reddy, my lord, there is another judgment of earlier of 1951. And that judgment is also on the same line.
No, if it is under adverse position, not required,
It is on adverse position.
not required.
Yes.
I think this is sufficient in respect of adverse.
Yes, my
position.
there is a constitutional judgment on the same line that if the initial entry is through an illegal means, then question of adverse position will come. Para 17, my lord. Just 2-3 lines I can show, my lord. Para 17. No, I'll not read the entire paragraph. Para 17 of mechanism.
Yes.
What in these circumstances was the legal position of the respondent corporation and its predecessor in title in relation to the land in question? They were in possession of the land to which they had no legal title at all. Therefore, the position of the respondent corporation and its predecessor in title was that of a person having no legal title, but nevertheless holding possession of the land under the color of an invalid grant of the land in perpetuity and free from rent for the purpose of a market. Such possession not being referable to any legal title, it was prima facie adverse to the legal title of the government as a owner of the land from the very moment the predecessor in title of the respondent corporation took possession of the land under the invalid grant. This possession has continued openly as of right and uninterruptedly for over 70 years, and the respondent corporation has acquired the limited title to it, and its predecessor in title had been prescribing for during all this period. That is to say, the right to hold the land in perpetuity free from rent, but only for the purpose of the market in terms of government expense. So, if the initial entry or possession is not referable to any legal document, then my possession from day one becomes adverse. This is what this is a constitutional judgment, my lord, of 1951. So that is the case I am trying to impress upon your lordship, my lord. That in our case, since the date of possession on the basis of mutation and my claim that there was an oral sale which I have not been able to prove, and I have not been able to prove any document of title for my mutation in respect of the land. That shows that my initial possession is not referable to any legal title. That is my submission, madam. My initial possession is not referable to any legal title, and from that date, we have been continuously and openly, without any interruption from the plaintiff. They have left the village and gone to some other village, leaving the possession to us, so that we can enjoy it. So that being the position, my lord, it's a clear case where I have been possessing the land adverse to the interest of the plaintiff, and since 1975, there is a clear admission. So far as, my lord, the judgment of 2010 is concerned, my lord, my submission will be, here is a case where the possession of the plaintiff or the defendant in respect of suit land is a material issue, and for a non-consideration of a clear admission on the part of the plaintiff, which will reverse the finding of the entire case, my lord. This finding of fact recorded by the first appellate court, my lord, can be reversed in second appeal, and that judgment will not come in the way. My lord, I'll look into the judgment your lordship has pointed out, my 2010 Madhavan's case, my lord. I'll again read, and if necessary, my lord, I'll cite one more judgment if your lordship so desire. At 2 o'clock, I'll give it, my lord, 2 days. So that being the position, my lord, the first separate course, my submission is that first separate course finding on issue number 1 is absolutely perverse, and this requires interference, and the plaintiff suit may be dismissed, and the defendant will come to issue. That's all, man.
Yes,
My lord, so far as my lord and senior claims submission that the additional, my lord, substantial question of law lordship. My lord, so I may be given some opportunity to my lord oppose that, my lord, against.
no, that was his submission.
Yes, lord.
We have not framed it now.
Yes. As regards, my lord, my lord, facts of the case, lordship. My learned friend has submitted, my lord, the evidence of PW1 lordship. My lord, only one sentence, lordship, that is, my lord, line of my lord suggestion, lordship. That may be probably, my lord, was suggestion.
No, it is not a suggestion. You
But
read the line.
it was at the last sentence, lordship. Now, 2 parts, lordship, in this case, lordship. One is, my lord, the defendant's plea was that the land was purchased on the basis of, my lord, sale deed, oral sale deed, and another registered sale deed was also exhibited. My lord, on that basis, they claimed, my lord, their title on, my lord, lawful documents, lordship. But failed to establish that those documents, the proof those documents, then subsequently the plea of adverse possession has been taken, lordship. In paragraph 14 of the WS law, written statement, lordship. You lordship kindly see paragraph 14 of the written statement. What is their plea? Lordship. At page 110.
Yes.
That this share of Nur Mahmud has been described.
110. Page number?
Page number 110, paragraph 14. Lordship.
Yes.
That the share of Nur Mahmud has been described in the plaint as 1 biga 1 kata 0 lesa of land in the number 148, 0 biga 1 kata 15 lesa of land in the number 149 had been under the possession of Nur Mahmud. In those days, the value of the suit land was too low, and against a petty consideration of ₹90, Nur Mahmud transferred the suit land to Ahmed Ali, son of Muhammad Ali, orally, and put Ahmed Ali in exclusive possession of the land, and thereafter mutated the land in favor of Ahmed Ali to mark the transfer. Such transfer and mutation have vividly been described in the Jamabandi of PP number 101 of village Dakalia Para of Moza Gilazari as per the order dated 13/3/1975 of the C. Barbeta. This fact of transfer of the land from Nur Muhammad to Ahmad Ali has not been described in the plaint, and as such, the plaintiffs have been kept matter in secret and concealed. As the total landed property of the said Dag 148 has been transferred to Ahmad Ali, so the name of Ahmad Ali, son of Muhammad Ali, has already been mutated in the land recorded in place of Nur Muhammad, the Pattadar number 2, and since then the family members of Ahmad Ali had been possessing the land completely, and no portion of the suit land had been possessed by the legal heirs of Nur Mahmud. After the death of Ahmad Ali, the Pattadar number 3, Namzari of Nurul Islam, son of Ahmed Ali, has been inserted in the Sita by the order dated 30/3/1995 of the HDC Barbeta. The Pattadar number 3, Ahmad Ali, also given some land to other brothers such as Gumar Ali and Tariq Hussain. during the lifetime of Ahmad Ali, the Ismaili landed properties of Ahmad Ali and Gomar Ali and Tariq Hussain had amicably been divided amongst the family members of Ahmad Ali, Gomar Ali, and Tariq Hussain. And under this amicable family portion, the partition, the landed property of that number 148, covered by periodic patta number 101, has been given to possession of Gomar Ali, who is aliving, and on behalf of Gomar Ali, his two sons, Abdul Mannan and Abdul Khalek, have been possessing and since 1980, but the names of Gomar Ali or Abdul Mannan or Abdul Khalek had not yet been mutated in the land record of Dag number 148. But there is no dispute in between Nurul Islam and Gomar Ali, as the father of Nurul Islam, namely Ahmad Ali, and the father of Abdul Mannan, namely Gomar Ali, were brother from common parents. That it may be noted here that plaintiff number 1, Farman Ali, and the plaintiff number 5, 6, 7 have been residing presently at Vilas Kirkira, Block 12, within Moza, Paka, within the area of Pias, Sorthabari. Further, the plaintiff number 2, 3, Abdul Zainal and Sajeda Begum have been residing at Vilas Bogaijanpara, Moza, Gilazari. It may also be noted that the plaintiff number 4, Ruksan Nessa, daughter of Nur Muhammad, has been still living at Vilas Datarbai. Hence, the present address of the plaintiff given in the plaintiff is completely wrong and not true, and thus the plaintiff approach is a complete falsity. That since 13/3/1975 till the date of submission of the suit, about more than 30 years have been passed. As such, the provisions of Section 90 of the Evidence Act and the Section 27 of the Limitation Act may be applicable, and hence no type of demand of the plaintiffs for landed property as claimed and stated in the Schedule B can raise at all. That it is now well recognized and well accepted fact that the patta number 2, Nur Mahmud, transferred the suit land to Ahmad Ali, followed by Sita mutation dated 13/3/1975, and since then the said Ahmad Ali had been possessing the same land in time of amicable partition of landed properties among the family members of Ahmad Ali. The said landed property had been given under the possession of Gomar Ali, the younger brother of Ahmad Ali. Since the transfer of the land from Nur Mahmud to Ahmad Ali, the legal heirs of Nur Mahmud, knowing the fact of the transfer of the land, had gone to various places such as the plaintiff number 1. I had gone to Kirkira, block number 12, within Moza Paka, and the legal heirs of Abdul Rashid, that in plaintiff number 5, 6, 7 have also been residing at the Kirkira since 1975, and the plaintiff number 2, 3 had been residing at Bogaijanpara, and the plaintiff number 4 has been residing at Vitarbori, and such that after mutation, this name of the plaintiff number 1 and others in the year 1976, they have no copy of the sum of Ahmad Ali, son of Muhammad Ali, on 13/3/75, that the mutation of the plaintiffs reserved nothing but outright dismissal. It is therefore paid that honor would be, my lord. This is the, my lord, a plea, my lord, of the defendant's lordship. There is no specific plea of adverse possession lordship. Only, my lord.
No, this is this D, point number D,
Yes,
more than 30 years.
more than 30 years. This is, my lord. This is, my lord, as per, my lord, section 27 lordship, the limitation, my lord, clause is been inserted lordship. But for adverse possession lordship, specifically should be there that the land is under my lord, absolute possession, my lord, publicly, without interruption, without any disturbance, and without objection, and continuous possession. That plea is not there in the, my lord, plea. This WS lordship. My lord, before that, my lord, the another, my lord, in the during evidence lordship, tried to, my lord, prove their case that the land was transferred to them by unregistered oral sale deed, and another sale deed was also exhibited, that is registered sale deed, that was failed to be proved lordship. Now, in another in a later stage, my lord, this, in the evidence, my lord, Ramabandi, my lord, it is found that the land was, my lord, mutated, my lord, on, my lord, relinquishment. That is Shiksha transfer. This Shiksha transfer is not one. Absolutely all the things are contradictory. My lord, not contradictory is a defendant's contradictory is permissible. Now, this is a my lord, matter of adverse possession lordship. The burden of proof, my lord, this is the very strict lordship. The Honorable Supreme Court also in various judgments has, my lord, held. In case of adverse possession, plea of adverse possession, that should be proved, my lord, strictly lordship. My lord, in this case, nothing, no evidence is, my lord, strict evidence is not proved lordship. Although this is a preponderance of probabilities, but that is also not better than the evidence of the plaintiff lordship. They are plaintiff, my lord, PWs, the evidence are all total contradictory. One is oral evidence, another is registered sale deed, another is Shiksha mutation. Then, my lord, plea of adverse possession lordship. This once the attempt to prove their case by my lord, exhibiting lawful documents, plea of lawful documents, after failing that, the adverse possession cannot be entertained lordship. Plea of adverse possession cannot be entertained lordship. Now the first appellate court at the first instance lordship, why the case was remanded lordship. At the time of remand, all the issues were, my lord, decided against the, my lord, defendants lordship in favor of the plaintiffs. Now, only the adverse possession, my lord, the case was remanded, my lord, only because of, my lord, the judgment of the Honorable High Court lordship. That judgment, and that was remanded to consider the adverse possession lordship, the plea of adverse possession now. Now the evidence, my lord, PW1, the learned first appellate court in the second instance lordship. Kindly see what evidences were considered. That is discussed lordship. At page 82 lordship. At page 82 lordship. During trial, on paragraph 9. During trial, as noted earlier, plaintiff side submitted evidence for examination in chief and also cross-examined trials prior to implement of the defendant number 2 and 3, then after implement of the defendant numbers 2 and 3, and lastly, again after remand of the suit. It may be noted that the contents of the plaintiff's affidavit for examination in chief are almost same in all the 3 times, and way of cross-examination is almost similar. Hence, the affidavit submitted for the last time after remand of the suit is considered while deciding this appeal. It may be noted here that at the initial stage, plaintiff side examined Oman Ali as PW1 and Motleb Ali as PW2 and Mohammad Nazamuddin as PW3. After implement of the defendant number 2 and 3 by way of amendment of the plaintiff, again Oman Ali's affidavit for evidence was marked as PW4, and Nazamuddin's affidavit for evidence was marked as PW5. Thereafter, on remand of the suit, Oman Ali has submitted fresh affidavit for cross-examination in chief as PW1, Abdul Motleb Ali as PW2, and Nazamuddin as PW3. In view of the latest affidavit, the earlier affidavit for evidence filed in the year 2006 and 2008 are not considered. This is not challenge. Now, on the other hand, the defendant side prior to implement examine Nurul Islam as DW1 and one Akmal Ali, Akmat Ali as DW2. After implement of defendant numbers 2 and 3, defendant number 1 Nurul Islam submitted fresh affidavit for examination in chief as DW1 and 1 Abdul Manan as DW3. The defendant side also examined 1 Lat Mondal as DW4. After remand of the suit, defendant side submitted fresh affidavit for witnesses Ahmad Ali, which was marked as DW4. But during cross-examination, the same was marked as DW5. It may further be noted here that after remand of the suit, DW1 was re-examined, wherein he brought the affidavit submitted by him for evidence in the year 2006 on the ground of proving the documents submitted initially in the year 2006. As such, the evidence of defendant number 1, Nurul Islam, has to be considered in the light of his two affidavits. Examination in chief of Akmat Ali as filed in the year 2006 is not considered in view of his fresh affidavit in the year 2010. Now, after remand lordship, only the evidence of DW1, my lord, submitted in 2006 that has been, my lord, recorded, that is considered, my lord, and that was not with the care of the, my lord, defendant's lordship, and the affidavit submitted after remand lordship, that was considered, my lord, as evidence, my lord, without any objection from the, my lord, defendant's side, my lord. Now, those evidence have been examined, my lord. The case was remanded in 2010 lordship. My lord, my learned senior friend has, my lord, highlighted the evidence one line, my lord, that was way back in 2006 lordship. That was not considered, and that was at the time of it was not, my lord, taking consideration, it was not, my lord, objected lordship. Now, cross-examination in 2000 after remand lordship. My lord, kindly see that part, like, because I'm, my lord, I'm submitting as regards, my lord, the evidence, because that is has been, my lord, placed before your lordship. Did PW1, my lord, it was submitted on, it was examined on 27th day of August 2010 for Manali. Twenty-seventh of August 2010 was cross examination was. The evidence, my lord, submitted before lordship, my lord, way back in the examining way back 2006 lordship, that was not considered lordship. Because, my lord, no objection, that was consent, my lord, was there, my lord. Now, fresh evidence 27th of August 2010 cross examination lordship, PW1. Lordship got it.
Can you show from the from the file?
Photocopies of the certified copy, lordship.
Yes, 6/8/2000.
27th day of August 2010.
Cross-examination.
Cross-examination, Lordship, my lord. The chief is almost, my lord, Sam in,
Yes, yes.
my lord. মই বৰ্তমান কিৰকিৰা ৰিজাৰ্ভত থাকো। কিৰকিৰা ৰিজাৰ্ভৰ পৰা ঢাকালিয়া পাৰা দূৰত্ব 15-20 কিলোমিটাৰ হ'ব। কিৰকিৰা ৰিজাৰ্ভত থকা মোৰ 4 বছৰ হৈছে। ঢাকালিয়া পাৰা গাঁৱৰ 101 নম্বৰ দাগৰ মোৰ ঘৰ বস্তি আছে। ঢাকালিয়া পাৰা গাঁৱৰ মোৰ বস্তিত থকা মানুহবিলাক আৰু তিৰোতাবিলাক মোৰ স্ত্ৰী নহয়। 2005 চনত মোক বিবাদীগণে বলপূৰ্বক খেদি দিয়ে। বিবাদীয় মাটিৰ পৰা কোন মাহত খেদিছে মই নাজানো। আমি আজি কিমান চন মই নাজানো। মোৰ জন্ম কোন তাৰিখত কোন চনত নাজানো। আৰু মই ইংৰাজী কোন চনত বিয়া কৰাইছিলো নাজানো। মোক যেতিয়া খেদি দিয়ে মাটিৰ পৰা তেতিয়া মোৰ সেই ঠাইত ঘৰ আছিল। মোক মাৰি ধৰি খেদি দিছিলে আৰু ইয়াৰ বাবে ফৌজদাৰী গোচৰ দিছিলো এইখন আদালততে। বিবাদীয়ে বছৰীয়া মাটিত কেতিয়া নামজাৰি কৰি লৈছে মই নাজানো। এই মাটিত মোৰ বাবা নুৰ মহম্মদ আছিলে। মই 2005 চনত ঢাকালিয়া পাৰা গাঁৱৰ মাটিৰ পৰা গৈছো। পিছত কয় 2005 তাৰিখে মই গুচি যাওঁ ঢাকালিয়া পৰা কিন্তু চনটো মনত নাই। বিবাদীগণে নুৰ মহম্মদৰ পৰা মিছাকৈ খেৰিত কৰি লোৱা বুলি কয় কিন্তু আচলতে মই পাওঁ বিবাদে মাটিখিনি। My lord, now no suggestion, my lord, no dispute as regards this, my lord, evidence, positive evidence, lordship. No suggestion is there, not denied, my lord, this evidence, my lord, on during cross-examination, lordship. Now, PW2, lordship.
No, they have already cross-examined the PW1.
Cross-examined, lordship, but it is no suggestion, this positive evidence, lordship, that
What suggestion? They
not
have,
denied,
they
not
have
disputed.
already suggested
not
in the
disputed.
earlier round of cross-examination.
Now, earlier round of cross-examination, that, my lord, cross-examination was not considered because, my lord, no objection was there, my lord, with application, lordship. With application, the evidence of, my lord, Akmal Ali, my lord, the DW1, lordship. That was considered, that is the, my lord, pair of the, my lord, defendant, my lord. But as regards consideration of this evidence, lordship, no objection was raised, no, earlier, my lord, cross-examination, my lord, that was not brought on record, my lord, that saying that you have stated so and so, so and so. That is also not.
No, why that is necessary?
Not stated here.
Maybe,
is
but the earlier round of cross-examination is already there.
It is already there, but the honorable.
Can they score? No, can any court ignore the same?
And that should be, my lord, because, my lord, the evidence was taken afresh because, my lord, the learned, my lord, appellate court at first and remanding the court, lordship. My lord, directed to, my lord, take a fresh evidence, lordship. That is why fresh evidence was taken, lordship. The affidavit, my lord, in chief also, my lord, submitted a fresh, lordship. So all the FCT, my lord, were afresh, my lord. My lord, if any contradiction was there, that ought to have been, my lord, brought to the notice, my lord, in during this cross-examination, lordship. And dispute should have been there. No dispute is there, lordship. My lord, it is a positive evidence, lordship. It cannot be ignored, lordship. My lord, the last tense, my lord. Now, PW2, lordship. PW2 Motleb Ali. Vivadia Mati. It is on the same day it was examined. Vivadia Mati Purbote Formanor Deotak Nur Mohammedor Asil. Vivadia Mati Vivadie Pabo Lage Nur Mohammedor Lora Hisabe. Into Vivadigone Vedakol Kori Rakit Hoise. Vivadigone Nur Mohammedor Kora Buli দাবি করে 2005 চনৰ পৰা বিবাদীয়ে মাটিত আছে। ইংৰাজী 2016-2005 তাৰিখত ইংৰাজী 16-10-2005 তাৰিখে বিবাদে মাটি দখল কৰিছে। 145 নম্বৰ দাগত 85 লেচা 249 নম্বৰ দাগত 35 লেচা মাটি আছে। মোৰ মাটিৰ দাগ নম্বৰ হল 348 আৰু ইয়াত মাটি 1.5 বিঘা আছে। বিবাদীয়গণ আগতে দাবালিয়া পাৰাত আছিল। This is PW2, my lord. Against this, no, my lord, dispute is there, lordship. Now, Now DW lordship, this is evidence of my lord, positive, my lord, plenty witnesses lordship. This is not disputed, this is positive witness, my lord. As regards the 2005, they have been, he has, my lord, plenty was, my lord, dispossessed lordship. Clear evidence lordship. It is not, my lord, under dispute lordship. Now, my lord, DW1 lordship. Ahmad Ali, his evidence was, my lord, taken, my lord, cross-examination lordship. It was examined on 29th of November 2010.
DW?
He is DW5 lordship, Ahmad Ali. Earlier he was DW1 lordship. Ahmad Ali, DW1.
Yes.
বিবাদীয় মাটি দাবালিয়াপাড়া গাঁৱত এই গোচৰটো 1 বিঘা 10 লেচা 1 বিঘা 20 লেচা লয় হৈছে। মই এই গোচৰত আগতে সাক্ষী দিছো। বিবাদীয় মাটিৰ দাগ আৰু পাট্টা নম্বৰ বিবাদীয়ে কৈছে 148 নম্বৰ দাগত 85 লেচা আৰু 140 নম্বৰ দাগত 45 লেচা মাটি আছে। বিবাদীয় মাটি নুৰ মহম্মদৰ আছিল। তেওঁৰ ল'ৰা ৰছিদ আলীয়ে এই বিবাদী মাটি বিক্ৰী কৰিছে। আহমদ আলীয়ে খৰিদ কৰিছে। নামজাৰি কৰি এই মাটি খৰিদ কৰিছে। খৰিদা হিচাপে চিঠা নামজাৰি কৰিছে বিবাদীয় মাটি। আহমদ আলী নুৰ মহম্মদৰ কোনো আত্মীয় নহয়। আহমদ আলীয়ে ঘৰবস্তি কৰিছিল খৰিদা মাটি। নুৰ মহম্মদৰ ঘৰবস্তি আহমদ আলীয়ে বসবাস কৰিবলৈ লয়। নুৰ মহম্মদৰ ঘৰবস্তিতে আহমদ আলীয়ে বসবাস কৰিব লয় আৰু মেৰামতি কৰি আহমদ আলীয়ে সেই মাটি থকা নাই কিন্তু তেওঁৰ ভতিজা আব্দুল মান্নান থাকিবলৈ লয়। এইটো সত্য নহয় যে আহমদ আলীয়ে বিবাদীয় মাটি খৰিদ কৰি আছিলে। এইটো সত্য নহয় যে ফৰমান আলীয়ে বেদখল কৰিছে। বিবাদীগণে ফৰমান আলীয়ে নিজে দখল দি থৈ গৈছে। বিবাদীৰ পিতা এইটো সত্য নহয় যে ফৰমান আলীক বিবাদীগণে বলপূৰ্বক বেদখল কৰে। এইটো সত্য নহয় যে আহমদ আলীয়ে বিবাদীগণে মাটি দখল কৰিছে। My lord, no, my lord, proof of my lord adverse possession lordship. No evidence lordship. My lord, this, my lord, in case of plea of adverse possession, my lord, the evidence should be, my lord, strict, concrete, open, public, and, my lord, notorious as well as, my lord, the continuous possession lordship. My lord, my learned friend has, my lord, highlighted the only one line, my lord, that was, my lord, stated in 2006 lordship, that was not brought on record during fresh evidence lordship.
No, why it is necessary? They have already brought on record.
My lord,
Why on the same point they will cross-examine the witness?
my lord, fresh affidavit in, after fresh affidavit in chief lordship, that was cross-examined lordship. That is, even then, my lord, DW1, it is the burden of the, it is the burden of the defendants to prove the adverse possession lordship.
No, there was no direction of the first appellate court not to read the earlier evidence.
Now, it was not there, lordship.
Then
Now, direction is, my lord, to, my lord, take fresh evidence lordship, if required lordship.
no, if such direction is not there, it cannot be ignored.
That itself is a ground to set aside the judgment passed by the first court. Your lordship has seen, my lord, he has recorded the judgment. Earlier evidence he has not considered.
Now, second evidence, it is positive lordship, it is not disputed lordship.
That is another thing, but then earlier evidence cannot be
What is
ignored.
What about, my lord, burden of, my lord, proving the, my lord, adverse possession lordship? Nothing is there lordship. My lord, my title is not denied lordship. It is my property, no more property. My lord, the mutation, my lord, one and minor contradiction, it is, my lord, not material lordship. Contradiction is, my lord, one say this oral, my lord, cell deed. Another is registered cell deed. Once, my lord, it is
forget
stated
about that.
mutation
Forget
transfer
about that.
lordship.
come to adverse position only. The additional issue framed by the first appellate court while remanding the matter to the trial court.
Yes, my lord, 1A, issue number 1A.
Issue
Lordship.
number 1A.
Yes. That is at page 85, Lordship. Before proceeding further, it may be noted here that as per the order of this court while remanding PA number 4 of 2009, this court has directed the learned trial court to frame an additional issue as to whether the defendants have possessing the suit land adversely to the plaintiffs for a statutory period of 12 years, which has the effect of extinguishing title of the plaintiffs by operation of section 27 of the Limitation Act. Learned trial court, after getting back the record by the order dated 3/5/2010, framed the additional issue as above has taken up the said additional issue as issue number 1A by keeping the issue number 3 intact. This issue is the crux of the suit and hence same is taken up before the other issues. The defendants cite in their WS at paragraph 14A under the head of real facts has admitted that the original Patadar Nur Mahmud was the owner for the plot of land measuring 1 biga 1 kata 0 lesa in the number 148 and 0 biga 1 kata 15 lesa in the number 149. In those days, the value of the suit land was too low and against a petty consideration of ₹90. Said Nur Mahmud transferred the said suit land to Ahmad Ali, son of Muhammad Ali orally, and put Ahmad Ali in exclusive possession of the land and thereafter meted the land in favor of Ahmad Ali to mark the transfer. Such transfer and mutation have vividly been described in the Normally of PP number 101 as per the order dated 13/3/1975 of the learned SDC, Barbados. Since then, the family members of Ahmad Ali have been possessing the land and no portion of the suit land was possessed by the legal heirs of Nur Mahmud. After the death of Ahmad Ali, name of the defendant number 1 was inserted by order dated 30/3/1995. My lord, this may be my lord, very important. After the death of Ahmad Ali, name of the defendant number 1 was inserted by order dated 30/3/1995. At paragraph 14D of WS, it has also been pleaded that since 13/3/75 till the date of submission of the suit, about more than 30 years have been passed, and as such the provisions of section 90 of the Evidence Act and section 27 of the Limitation Act will be applicable. Hence, plaintiffs cannot raise any demand regarding the suit property. It is also pleaded that subsequently this said land of the tag number 1 of the tag number 148 fallen in the share of brother of Ahmad Ali, namely Gumar Ali, and on their death, their son Abdul Mannan and Abdul Khaled are possessing this land since 1980. In view of above pleadings, the defendants have denied the allegation of disposition brought by the plaintiffs. Now, as regards, my lord, possession of Gumar Ali lordship, they are pleaded, my lord, 1980 lordship. 1980, Ahmad Ali, my lord, as per plea, my lord, plea of the my lord defendants, Ahmad Ali, my lord, in 1975. He took possession, my lord, as per my lord, defendants, my lord, plea. Now, my lord, only one witness, my lord, in the evidence, my lord, 1975, Gumar Ali was in possession, my lord. That is in contradiction with this, my lord, the plea of the my lord, defendants, my lord. If the defendants please, my lord, see, after taking possession of Ahmad Ali and thereafter, my lord, not in 75, my lord, it is stated in the, it is not stated in my lord, WS lordship. My lord, that portion, my lord, that is my lord, I don't know why that was, my lord, stated, my lord, that is not, cannot be isolated, my lord, from the other evidence lordship. That should be read with, my lord, other evidence of the, my lord, PW1, my lord. But as regards, my lord, the evidence of the plea of the, my lord, defendant's lordship, that was, my lord, not 1975. My lord, Gomarli was not in possession in 1975, lordship. He was Ahmad Ali, lordship. So that, my lord, the statements, my lord, has no, my lord, in my humble submission, cannot be used in, my lord, taking advantage of adverse possession, lordship. Now, next 20 page. In the WS, it should have been, my lord, saying that Gomarali is in 1975, lordship. It is not stated. Only one line, my lord, is stated that judgment will not be isolated from other evidence, my lord, other part. Possessions denied, lordship. Now, paragraph 20, lordship. On the cursory reading of the WS, particularly at paragraph 14 of WS as noted above, the defendants nowhere in specific words claim that they are possessing the land adversely against the interest of the plaintiff or the other minimum requirements of adverse possession. The principle, by neck, plena, and neck, precaria, that is possessing the land openly, notoriously, and continuously. However, in view of the ratio of the cited case law of Raju Saha Supra as relied upon by the learned advocate for the respondents might be as a matter of abundant precaution, may learned decision in office has remanded the suit by stemming the above additional issue with a direction to consider this aspect. In course of appeal hearing, learned advocate for the appellants has argued that although the issue has been framed, yet as the defendants have claimed to have purchased the land on the strength of ₹90 and delivery of possession and getting mutation, they cannot be allowed to take the shelter of possessing the land adversely, and the defendant can only succeed if he proves the purchase by better evidence than plaintiff. It is also argued that taking the plea of lawful purchase in one hand and on the other hand claiming their possession adversely, both the pleadings are mutually destructive and hence cannot be allowed to stand simultaneously. I found sufficient force in the submission of learned counsel for the appellant's side. This is, my lord, the submission, my submission, my lord. My lord, once stated, my lord, lawfully purchased and occupied and mutated. My lord, another place, my lord, stated, my
No,
lord,
that is held to be illegal.
lordship.
The first appellate court already held that the same is illegal.
Yes, my lord, lordship. Now, second plea, adverse position cannot be taken, lordship. This is also my findings of the learned first appellate court. Honorable Supreme Court of India in the reported case of in Anna Sahib, Babu Sahib Patel, so and so, this court held, where possession can be referred to a lawful title, it will not be considered to be adverse. The reason behind that a person whose possession can be referred to a lawful title will not be permitted to show that his possession was hostile to another's title. One who holds possession on behalf of another does not, by mere denial of that other's title, make his possession adverse so as to give himself the benefit of cessitude of limitation. Therefore, a person who enters into possession having a lawful title cannot divest another of that title by pretending that he had no title at all. Here in this case, lordship, defendants that I have title by oral cell date, my lord, Sita transfer, my lord, when they fails, my lord, my lord, adverse possession, my lord, it cannot be permitted, lordship. This is the proposition of honorable Supreme Court, lordship. Now, My learned friend has, my lord, submitted a judgment, lordship. My lord saying that, my lord, adverse position, my lord, last judgment, my learned friend has submitted. That is also favor my case, lordship.
How?
Because how, my lord, the continuous possession, my lord, mere continuous possession is not, my lord, adverse position, my lord. My lord, on the other hand, my lord, could be proved that I have no, my lord, title at all. I have no title, but I am in continuous possession, in public possession, open possession, without an interruption. This is the principle of, my lord, adverse possession, my lord. My lord, once, my lord, right to my lord, this is my judgment, my lord, friend, senior friend cited lordship. I have, my lord, I had attention to that judgment, lordship. Now, that was the different case, lordship. That is not the case. This is the case, my lord. My case is, my lord, once plea was taken to probe with lawful documents, my lord, and then, my lord, another, my lord, claim adverse possession. That is not permissible, lordship. Now, the next, my lord, ratio, paragraph 23, the above ratio clearly indicates that if a party claim acquiring lawful title, they are debarred from taking the plea of adverse possession on the basis of their long possession. The defendant shall have to be successful on his pleadings of acquiring lawful title, and in the event of his failure, he has to go. Thus, if a defendant take the plea of purchasing land lawfully, he cannot be allowed to raise the plea of adverse possession. Most probably, for the reason the defendants at paragraph 14 of their WS simply claimed their long possession since 1975 without asserting the plea of notorious and hostile possession against the interest of the plaintiff. This plea has been raised in argument stage by relying on the reported case of Raju Saha. Honorable Guwahati High Court, in the reported case of Raju Saha, reported in so and so, held as follows. I have carefully considered the arguments advanced by the learned counsel for the parties. I have also carefully gone through the pleadings of the parties from the pleadings in the objection to counterclaim as pointed out by the learned counsel for the respondents, and as quoted above. It is more than convincing that although no term like adverse possession has been expressly employed, all the facts necessary to constitute adverse possession have been set out clearly and unambiguously therein, and it is so implicit that appellants, defendants were not taken by surprise, thereby leaving any scope to take an objection that the question of adverse possession cannot be raised or dealt with in the second appeal. No doubt, the courts below, for reasons best known to them only, did not frame a definite issue on the question of adverse possession, but nevertheless, the respondent plaintiff yet present and convincing evidence to establish their claim of adverse possession over the suit land. The lower courts below duly considered the said evidence and came to a finding that the possession of the suit land by the plaintiff respondent continued uninterruptedly since the year 1964 and against the true owner, if any, and accordingly they acquired the right by adverse possession against the true owner. After all, the question of adverse possession is basically a question of fact, and the same is to be proved by evidence. This fact of adverse possession having been proved by adducing sufficient evidence, the same cannot be interfered with in the second appeal. In the above ratio of Honorable Guwahati High Court is not applicable in present case in hand, because the defendant side in their written statement has taken the plea of lawful purchase. That is why it was not made applicable, lordship. Lawful purchase, then my lord adverse taken the plea of adverse possession. My lord, this paragraph 25, my lord, is, my lord, this is crux of the case, lordship.
So, Mr. Mozumdar, You have submitted that there is one judgment of Supreme Court that the defendant can take both the plea.
Yes.
Where is that judgment?
Well, I have found out, I'll give the printout at 2 o'clock.
2.
I have found out already. The judgment which my lordship has referred to, that where the Honorable Supreme Court has recently said, this printout lordship has taken, that even if there is an error committed by the first appellate court, that will not be a ground for intervening in the second appeal. And I found out this is reported case otherwise. Reported in 2009, 5 years, 264. I have noted down what you can. The judgment of in that Madhavan Nair, which you also pointed out, that also I have found out what I was saying, possibly it is there. But means that I have taken a printout of that judgment.
Madhavan.
Mine. Very interesting. That is what I was saying. Possibly subject to correction, my lord. Possibly that is there. Lordship may finally see the judgment. There, this judgment is of only 3 paragraphs.
Pardon?
That judgment of Madhavan is only of 3 paragraphs. It's small judgment. That's what I'm saying. Para 3, this finding which the Honorable Supreme Court has referred is available in para 3. And look, in the middle, I have given a tick mark, my lord, starting with we. We are not able to find that the first appellate court either ignored any material evidence having bearing on the decision of the case or considered any evidence which was otherwise not admissible. These being the position, the High Court was not at all justified in interfering with the concurrent findings of fact. It is well settled that even if the first appellate court commits an error in recording finding of fact, that itself will not be a ground for High Court to upset the same. So in the previous line, my lord, the Supreme Court has used the word of caution that if that evidence is material, having a bearing on the decision of the case. So here is the case, my lord, that particular part of the evidence in my humble submission has a direct bearing on the decision of issue number 1A regarding adverse position, that whether the defendant or the plaintiff who was in possession of the land for the last so many years from 1975, that's a very, that has got a direct bearing on the issue. So if that evidence is not considered, my lord, even the Honorable Supreme Court say that no, because that was not a case where there was a non-consideration of any material evidence. So here it is very material, my lord. That is why Supreme Court says, my lord, it is not the case. We are unable to find that the first appellate court ignored any material evidence having bearing on the decision of the case. So here is possibly it is having a bearing on the case.
Okay.
That's the lordship.
So you want to distinguish the fact
My
of the
lord,
present
your-
case with that of other
Lordship is
judgment.
absolutely correct.
Okay.
I am deeply obliged.
If you lordship permit lordship,
Mr.
it is
Ahmed will
possible to-
resume at 2 o'clock.
if is it possible to fix another date lordship?
Why?
They have to, my lord, sir. My lord, obtains of judgment lordship.
Let
Maybe
me,
kept
let,
Aadhaar
let us,
lordship.
let us complete, and so far as
Aadhaar
judgment is
law.
concerned, he can be allowed to give judgment subsequently.
It may be kept part of lordship. I based lordship.
No, you continue today, you finish your argument.
My learned senior friend has my submit so many judgments lordship.
No, you can also furnish it. But you finish your oral argument.
Judgments he can give subsequently.
Judgment you can give subsequently.
If I am permitted, I will submit a letter on lordship.
Later on, I will permit you.
And other day
But
lordship.
you finish your oral argument today.
Lordship.
At 2 we will resume.
My lord, deeply obliged.
All right.
Well, begging apology,
Hmm.
begging apology,
Mhm.
because may I prefer listing the matter item number 15, that is matrimonial hearing. Is there no possible, may not be there possibility? Maybe fix this starting from second week of December, Miller. Maybe on 10th December, my
Item number 15.
15 Miller. on 10th.
Yes, madam, you are for respondent.
Yes, Your Lord.
Any objection?
On 10th of December, no.
Okay.
10th of December.
At 2 o'clock, my Lord.
2 o'clock.
10th December, 2 o'clock.
Okay.
My Lord.
On the pair being made by Mr.
Sibur.
Borua, learned counsel for the appellant, having not been objected by Ms. M. Jain, learned legal aid counsel. This is the matter on,
10th December.
okay,
At 2 o'clock.
2 o'clock, okay.
Highly obliged, my Lord.
Matter number 6 to continue.
But I'm on the filter to Lordship, just give me 5 minutes coming.
Okay, yes.
My lord, what lordship? Paragraph 26, lordship.
Hmm.
Says 18. Having taken into note of the above legal aspects, let me move to the evidence on record as to the nature of possession of the defendant's side. Let me look at the defendant's evidence as to whether they have been able to prove their plea of purchasing the land from Nur Mahmud by paying ₹90. It may be noted here that any sale of immovable property below ₹100 need not be made by registered instrument. It means that sale of the land at ₹90, if proved, has given a valid title to the purchaser. The first ground in support of their purchase, the defendants have taken is granting of mutation in favor of Ahmad Ali. On going through the certified copy of the Zawamadi, as proved by both the sides, it is clear that the name of Ahmad Ali, son of Muhammad Ali, the predecessor of the defendant number 1, was mutated as sharer of Nur Mahmud and not as purchaser. The said mutation did not reflect the transfer of land by way of sale at ₹90. The mutation entries as claimed by the defendants did not support their claim of sale of land by Nur Mahmud to Ahmad Ali. During evidence, the defendants have examined defendant number 1, Nurul Islam, SDW1, 1 Abdul Mannan, son of Kumar Ali, SDW2, and 1 Abdul Matlab, SDW3. In their examination in chief, they have asserted the facts of transferring the land at ₹90. However, DW1 in his cross-examination stated that he is not sure as to whether the contents of affidavit are in consonance with pleadings of his WS. He further admitted that he has no knowledge regarding transfer of land at consideration of ₹90. He further admitted that he has submitted an unregistered sale deed showing sale of the land, which was marked as Exhibit A by him. He was not present at the time of execution of Exhibit A. On going through the Exhibit A, it appears that on 10/3/1975, the plaintiffs and on behalf of plaintiff number 1, Horman Ali, his mother, Sarifun Nessa, transferred the land measuring 1 biga 1 kata at a price of ₹600 in favor of Ahmad Ali. The father of the defendant number 1, learned trial court, while discussing the evidence has rejected the Exhibit A and refused to rely on the same on the ground that in the WS, they have not taken the plea of executing Exhibit A by plaintiff side. It is true that in the WS, no such plea has been taken, but when the defendants have produced this document, which contradicts their claim of purchasing the land at a price of ₹90, it cannot be overlooked. The existence of Exhibit 1 shows that the plea taken by the defendant side of purchasing the land at ₹90 is false, and it damages the credibility of the evidence of the defendant's side. So far, it relates to their claim of purchasing the suit land at ₹90. Apart from this plaintiff side have also produced one registered sale deed, White Exhibit V, showing sale of 4 acres of land of tag number 147 at a price of ₹2,000, which was executed by the plaintiffs on 7/2/1975. Exhibit A was also executed on 10/3/75. It is in the evidence that the above 4 acres of land is contiguous to the said land. The existence of Exhibit B thus shows that in the year 1975, the valuation of the land as ₹500 shadow on the claim of defendant side that the suit land was sold at a price of ₹90. Normally, a civil court should not bother about the consideration amount of transfer if not challenged by the parties. But in this case, the plaintiff side has totally denied of transferring the suit land in favor of the plaintiff, in favor of the defendants. Defendants, to get their claim of purchase legitimized, has taken the plea of purchasing the land at ₹90 without any direct evidence of such purchase. Hence, it becomes necessary to consider the amount of consideration as an evidence to decide the genuineness of the claim of sale. The DW2 Abdul Mannan, whose examination has been recorded as DW3, stated that he did not know to read and write English, and hence he cannot say what was written in the affidavit for examination sheet. He also admitted that the land was given to them by Ahmad Ali and their names have not mutated. DW5 Ahmad Ali, in his cross-examination, admitted that Rashid Ali sold the suit land by way of Sita mutation and further admitted that Ahmad Ali was not relative of Nur Mahmud. On going through the record, it appears that Rashid Ali has no mutation on the date of alleged sale and he has no absolute right to sell the Schedule B land by Sita mutation. Transferring of land by Sita mutation is not recognized by TP Act. From the above oral and documented evidence, it is clear that the defendants failed to prove their claim for purchasing the suit land at ₹90 from the plaintiffs, and thus they have not acquired any title over the same. Now, the defendants have failed to prove their lawful purchase, and having no express or implied pleading of possessing the land openly with hostile attitude, this court on its shown cannot make out a case of long possession into a case of adverse possession. Even then, as an issue was framed, let me consider the fact of possession over the suit land. The plaintiff side in their evidence and in their pleadings claimed that on 16/10/2005, the defendants asked the plaintiffs to vacate the suit land and also dispossessed them on the same day. The above facts has been reiterated by the plaintiffs in their affidavit for evidence submitted on 19/7/2010. During cross-examination, the PW1 Rahman Ali remained firm on the point of dispossession by defendants. He admitted that about 4 years back, he went to Kirkira Reserve, and in the year 2005, the defendants forcefully dispossessed him from the suit land. Though he cannot say about the English term, date, etc., but he asserted that at the time of disposition, he has his house on the suit land. PW2 Abdul Motleb, in his cross-examination, reiterated that since 2005, the plaintiffs are in possession. Since 2005, the plaintiffs are in possession of the suit land. On 16/10/2005, defendants took forcible possession over the suit land. PW3 Nazimuddin, though in his evidence cannot say about the difference between 1975 and 2005, but stated that disposition took place in winter days. He further stated that about the land presently possessing by the defendants. The plaintiffs had residential house, plaintiffs had residential houses. During cross-examination of PW1, PW2, and PW3, not a single suggestion was given against them, against the claim of the plaintiffs that the defendants dispossessed them in the year 2005. Evidence of the plaintiff's side clearly proved the fact that the plaintiffs were dispossessed in the year 2005. The evidence of the plaintiffs remained unshaken and reliable on the point of their possession till 2005. Hence, on this count, also the defendant side have failed to show that they have possessed the Suitland since 1975 uninterruptedly, continuously for more than 12 years. From the above discussion, it is clear that the defendant has failed on both the counts to establish their claim. Law is well settled that mutation in revenue record neither extinguish title nor creates any rights, any title. Every mutation must be backed by lawful title. Honorable Supreme Court of India in the reports case of Srimati Gitarani Pal so held that in the face of clear pleadings and the evidence on record, the High Court was wrong in reaching the conclusion that there was no pleadings and evidence regarding disposition. Even otherwise, in the face of the finding of the courts below that the appellant plaintiff had proved her title, it was not necessary for the High Court to go into the question of ascertaining the date of disposition. We therefore do not agree with the reasoning of the High Court and set aside the same. The Honorable Supreme Court of India in the reported case of Indira versus Arumugam and another held that when the suit is based on title possession, once the title is established on the basis of relevant documents under the evidence, unless the defendant proves the adverse possession for the prescriptive period, the plaintiff cannot be non-suited. In the present case in hand, it is admitted that Nur Mahmud was the original pattadar for the Suitland measuring 1 bighah 1 katha, and the plaintiffs are legal heirs of Said Nur Mahmud. As Said Nur Mahmud or his legal heirs has not transferred their title over Suitland in favor of Ahmad Ali, the same is subsisting in favor of the plaintiff. As the defendants have failed to prove their plea of purchase and as they are not legally allowed to take the plea of adverse possession, which otherwise also they have failed to prove, there is no question of extinguishment of title by operation of Section 27 of Limitation Act. While discussing this above issue, learned trial court was gone wrong and misread the evidence and failed to apply the law in proper perspective. Learned trial court, while deciding this issue, has overlooked the oral evidence of the plaintiff's side and wrongly rejected the Exhibit A, which is a proof of false plea on the part of defendant. Itself, the finding of the learned trial court needs interference, which I do not. Accordingly, this issue is answered against the defendant's side. Well, this is the crux of the issue number 1A. Now, a clearly stated lawsuit, no specific pleadings lawsuit. No, my lord, only two parts, one part, my lord, is false evidence. My lord, with defined plea, without defined evidence, one is teacher transfer, one is, my lord, oral evidence that was not proved, my lord, Exhibit A, the value of the land to suppress the, to, my lord, hide the registration, my lord, mislead the court, the value of the land was, my lord, projected as rupees 90, whereas the evidence of the available on record, the adjacent part is rupees value was at rupees 500 per bighah lawsuit. So everything was, my lord, false. It is held by the learned court below, my lord. Now, learned trial court lawsuit, they did not, my lord, consider this everything and did not appreciate this evidence lawsuit. Now, Only, my lord. Question is lordship, only, my lord, when failed lordship, adverse position or at my lord, single line, my lord, as regards section 27, plea of section 27 of the limitation is taken lordship. That is not enough lordship. In a judgment of the Honorable Supreme Court lordship, apart from the judgment discussed by the learned, my lord, the first appellate court lordship, this is the judgment of the Honorable Supreme Court, paragraph 3. This is a case, my lord, in which, my lord, the adverse position was claimed, my lord, on the basis of a document sale deed, my lord, that was voidable. My lord, no specific plea was taken, my lord, as like, my lord, the position was, my lord, space, my lord, continuous. My lord,
Which paragraph you have relied
paragraph 3,
upon?
lordship,
Paragraph?
paragraph 3. 1997, 7 FCC, 567. May I read, lordship? The petitioners admittedly had purchased the property in the years 1962-63 and 1963-64 from the original allottees. The government have allotted those lands as per Sagowali Street containing prohibition of alienation of the land. Subsequently, the Karnataka Scheduled Caste and Scheduled Tribes prohibition of transfer of certain lands Act 1978 was enacted, totally prohibiting the alienation up to a particular period. The proceedings were initiated against the petitioners for ejectment under the said act. All the authorities have concurrently held that alienation in favor of the petitioner was violation of the above rules and the said act, and hence the sales are voidable. When the case had come up before this court, while upholding the constitutionality of the act, directed the authorities to go into the question of adverse possession raised by the petitioners. The learned single judge has extracted the pleadings on adverse possession of the petitioners. Herein, the High Court had pointed out that there is no express plea of adverse possession except stating that after the purchase of the lands made by them, they remain in possession and enjoyment of the lands. What requires to be pleaded and proved is that the purchaser is disclaimed his title under which he came into possession, set up adverse possession with necessary enemas of asserting open and hostile title to the knowledge of the true owner, and the latter allowed the former without any let or hindrance to remain in possession and enjoyment of the property adverse to the interest of the true owner until the expiry of the prescribed period. The classical requirement of adverse possession is that it should be nec v nec claim nec v cario. After the considering the entire case law in that we have, the learned single judge has held thus. The contention raised by the petitioners that they have perfected their title in respect of the lands in question by adverse
No,
possession.
you come to the operative portion of the.
My lord, the wrong judgment, my lord, ultimately it was held that for adverse possession, the specific plea is required to be, my lord, taken in the my lord pleadings that they have been, my lord.
Which part of the judgment it is stated?
This is long, judgment paragraph 3 is very much long lawsuit. Paragraph 3, my lord, paragraph 4, it is in view of that.
No, you tell me in which part of the judgment Supreme Court has stated about the requirement of adverse possession.
My lord, paragraph third paragraph page 571 lordship. Therefore, lordship. Therefore, in the absence of crucial pleadings which constitute adverse possession and evidence to show that the petitioners have been in continuous and uninterrupted possession of the lands in question, claiming right, title, and interest in the lands, in question hostile to the title right, hostile to the title, right title and interest of the original grantees, the petitioners cannot claim that they have perfected their title by adverse possession. Therefore, the act does not apply as laid down by the Supreme Court instance. Well, this is the crux, lordship. Or my lord, availing the my lord benefit of adverse possession, my lord, the pleading should be specific. Herein, my lord, only my lord, section 27, apart from the my lord, first claim, lordship. After failing, my lord, section 27 alternative prayer was given, lordship. There is section 20, as about section 26 is a part by limitation, lord. Limitation, my lord. This is not specific plea, lordship, or adverse possession, saying that we are in adverse possession, or adverse may not be, my lord, specifically stated, lordship. It may be impliedly, lordship, that it is openly, my lord, publicly, continuous, my lord, and notoriously we are in possession. The plaintiffs have no objection here, they have knowledge. That is absent in the my lord pleading of the my lord defendants, lordship. That plea cannot be taken apart from the my lord other part, my lord, the claiming title
Okay.
on my lord.
Okay. So any other judgment on the point?
My lord, today I have not taken, my lord. Lord, it permits, lordship, I'll take other. On the other hand, one part, my lord. In 2000, my lord, 6, the evidence recorded by the prosecution, my lord, one sentence that is, my lord, favored by my lord, friend submitted, lordship. Other part has not been, my lord, highlighted, my lord. In other part, my lord, everything has been denied. My lord, the suggestions have been denied. My lord, he stated he was in possession, lordship. Other evidence of other witnesses have not been disputed. My lord, no, there is no problem. My lord, the DWs have not established the case saying that they have adverse possession, lord. Continuous uninterpreted possession. That is not, nothing is in there in the evidence of the DW. This is the burden of the, my lord, my defendants to prove adverse, not only, my lord, on preponderance of evidence.
No, why they repeat the same thing? They have already brought it on record.
My lord, that was my lord, that was after, my lord, evidence in sieve, lordship, what I am submitting, lordship. When evidence in sieve is, my lord, submitted afresh, my lord, the defendants got opportunity to cross-examine. During cross-examination, that was not taken, lordship.
Not necessarily, it is already on the record.
My lord,
The first round of cross-examination was not wiped out. It was already there.
even, my lord, even if, lordship, even assuming, my lord, that is, my lord, stated since 1975 in possession of, that, my lord, that is not sufficient, lordship. Without specific plea, without specific proof, that the three, my lord, criteria, as regards the adverse possession, lordship. That is not sufficient.
Okay.
That is in humble mastery. My lord, I may be allowed to further time to, my lord, other further, my lord, citations.
Judgment he can give, but with a copy to me so that I can understand what judgment.
Yes, yes.
Well, the two judgments I was referring to about the inconsistent plea the defendant can take. These are the two judgments. There are many. I have. The first one is a recent judgment of Calcutta High Court. It is reported in 2022. Supreme Calcutta 60760 Aniruddha Ghosh versus Somnath Ghosh. Lordship may straightway turn to page 4, my lord. Page markings are given at the bottom. Page 4, my lord. Lordship is got, my lord. On top, my lord, the second paragraph, first line is slightly blurred, my second paragraph. It is needless to say that in a civil proceeding, a defendant can take even inconsistent and contradictory plea in the same proceeding in support of his defense. Second one is, my lord, of the Honorable Supreme Court. This is reported in 2007, 5 SCC, page 602. I have given the Supreme Today version. Possibly Lordships are also having the software of Supreme Today. Somehow the presently
But SSC citation is there.
it is there, but
Okay,
paragraph,
well, no
only
problem.
paragraph number may not sometimes tell you.
Okay, no problem.
But I'm relying on only one paragraph, that is paragraph 27.
Hmm.
Even paragraph 21 for a moment kindly be seen, madam. At page 8.
Hmm.
Just two paragraphs I'll show, madam.
Hmm.
Para 21, such being the settled law, we must hold that in a case of amendment of a written statement, the courts are more liberal in allowing an amendment than that of a plaint, as the question of prejudice would be far less informal than in the later case. The so judgment, Baldev Singh judgment, BK Naran Pillai 2006, 6 498. Even the decision relied on by the plaintiff in Modi spinning Supra clearly recognizes that inconsistent plea can be taken in the pleadings. And I've seen their judgment of Modi's spinning. There, that was a Modi spinning was a case of amendment sought by the defendant. And so there, in that context, the court said that inconsistent plea can be taken. Now, Lordship may kindly turn to the next page, para 27. Since we have already held that in the case of an amendment of written statement, the defendant is entitled to take new defense and also to plead inconsistent stand. And in view of our discussions made herein above, that by making the application for amendment of written statement, admission was not at all withdrawn by the appellants, nor a totally inconsistent plea was taken by the appellants in their application for amendment of written statement. High Court had failed to appreciate that by proposed amendment, the appellants were not withdrawing their admission in respect of the half share in expenses. That is the facts of that case, mentioned. So, law is very clear. If there is an admission in
That's all right, but Mr. Mozumdar, you see, the trial court has, no, first appellate court has relied upon a decision of Supreme Court
my lord,
of the year 1995.
my lord. Yes.
Where it is clearly stated that that paragraph number 15.
my lord.
You come to page number 87.
Yes. Para 15, yes. Where possession can be referred to a lawful title. Is this the paragraph, my lord?
Yes, yes.
Where a possession can be referred to a lawful title, it will not be considered to be adverse. The reason being that a person whose possession can be referred to a lawful title will not be permitted to show that his possession was hostile to another's title. One who holds possession on behalf of another does not, by mere denial of that other's title, make his possession adverse so as to give himself the benefit of statute of limitation. Therefore, a person who enters into possession having a lawful title cannot divest another of that title by pretending that he had no title at all. And I am also relying on this. This judgment says, if you have entered into possession through a lawful title, subsequently you cannot say that this gentleman has no title because I have acquired title by adverse possession. This is what I am saying, my lord. My submission is, my lord, the first appellate court was called upon to decide as to whether by my initial entry, for which there was no sale deed, admittedly I took a plea of an oral sale, I could not prove it. Then I said there is an unregistered sale deed. Now, unregistered sale deed is naturally illegal because it is not in terms of section 19 and 49 of the Registration Act and section 54 of the Transfer of Property Act, which says that a immovable property of value more than 100 registered sale deed is necessary. So that first appellate court by a detailed discussion has held that I have not been able to prove my title.
No, that's all right. There is no dispute about
My
it.
lord,
The dispute is regarding this plea,
my lord.
that once you have taken the plea
Yes.
that you are legally entitled to,
Yes.
then you cannot again
My lord, lordship is correct.
take the plea for
Yes, lordship
this.
is correct. My lord, court below has come to a finding that I have taken a plea. Question is not what plea I have taken. Question is what ultimately has transpired in course of trial. It has been found that I have got, my lord, if I take a plea, and if that plea is taken to be final, then I have got title. I have not been able to prove that plea, my lord. There is a difference. Trial court I have seen in one paragraph has noted that since I have taken a plea that I have entered through a oral sale, there can't be any question of adverse possession. But that is in my humble opinion not correct, because my taking plea is not sufficient. What I have proved, I have not been able to prove my title. That is why, my lord, I have taken an adverse, inconsistent plea of adverse possession by showing that subsequently also there was mutation in favor of the next legal heir, and they were possessing. And I have shown, my lord, they themselves have admitted that my possession was since 1975. So my possession was continuous, uninterrupted. They left the village, they stayed elsewhere. And my initial entry, although I claim to be on the basis of an oral sale, but I have not been able to prove any oral sale, nor any registered sale deed. That being the position, my initial entry in terms of deed judgment also is not referable to any legal title. And that is why I am entitled to the plea of adverse possession, my lord. That is my submission. Trial court has, my lord, gone into error for the simple reason that trial court has said that since I have taken the plea, and if my plea is taken to be correct and accepted, then I have got title. If my plea that I have entered there on the basis of an oral sale is accepted to be correct, then I have got acquired title, my lord. But that cannot be held because I have not been able to prove oral sale nor any registered sale deed. Court has come to a clear finding that the value of the land is more than 100. Therefore, there has to be registered sale deed. I have not been able to prove a registered sale deed. So my entry or my possession from day one is not referable to any legal title. I am also relying on this part of the judgment of the Supreme Court. And so far as my learned friend's plea, my learned friend is harping on one thing that I have only mentioned about section 27. And I have not taken neck by, etc. I have not stated. My lord, if your lordship reads the written statement, my lord, entire written statement, I have given the full story as to what has happened during all these years, how we have occupied, how our original defendants, legal heirs have occupied the land by subsequent mutation. These are the facts which show that my possession and the nature of possession was hostile to them. And my lord, that is why, my lord, in the same paragraph 87, my lord, same page 87, paragraph 24, there is a reference of a judgment of our High Court, where the this honorable court has said in Raju Saha's case, my lord, I have carefully considered the arguments on page 87, paragraph 24. I have carefully considered the arguments advanced by the Learned Counsel for the parties. I have also carefully gone through the pleadings of the parties. From the pleadings in the objection to the counterclaim, as pointed out by the Learned Counsel for the respondents and as quoted above, it is more than convincing that although no term like adverse possession has been expressly employed, all the facts necessary to constitute adverse possession have been set out clearly and unambiguously therein, and it is so explicit that appellant defendants were not taken by surprise. My lord, in my written statement, I am just pointing out in 1 second, my lord. Lordship may kindly see at page 108 first.
No, just now we have read which paragraph?
This is from the judgment panel, page 74, I think. That is, I'm sorry, not 74, my lord, that is page 87. Page 87 of the judgment of the first appellate court, my lord.
Which paragraph?
Para 24, bill at the bottom, my lord. There the Raju Sahu's paragraph 10 has been quoted by the Learned Court below, my lord.
Okay.
And my lord, I was just pointing out, my lord, page 108 for a moment. I'm sorry, my lord, I'm just taking 1 minute of the lord's time. Page 108, lordship will find at the bottom. This is part of my written statement, my lord.
Yes.
Page 108. My lord, at the bottom, while I was replying to paragraph 5 of the plaint, I have further stated, it is humbly submitted by the defendants. Since the year 1975, the defendants have been possessing the land continuously with their dwelling houses thereon, and they had no occasion at any point of time to threaten the plaintiffs. Then, my lord, page 110, paragraph 14, in the real fact, I have elaborately stated how we are possessing. Elaborately, my lord. Para 14A, 14B, 14C, 14B. Para 14B at page 111, we have also said that Pattada number 3, Ahmed Ali also given some land to other brothers such as Umar Ali and Tarak Hussain. During the lifetime of Ahmad Ali, the Ajmali landed properties of Ahmad Ali and Gomar Ali and Tariq Hussain had amicably been divided amongst the family members of Ahmad Ali, Gomar Ali and Tariq Hussain. And under this amicable family portion, the landed property so-and-so has been given to possession of Gomar Ali, who is a living. And on behalf of Gomar Ali, his two sons, Abdul Mannan and Abdul Khalik, have been possessing the same land since 1980. But the names of Gomar Ali or Aman Ali or so-and-so have not been mutated in the land of so-and-so. But there is no dispute in between Nurul Islam and. So who else from the family members of the defendant are residing there? There is a family partition, and mutation was not there, but still they are possessing, and in the local inspection, their names have come. So it is not that somebody has claimed possession of a plot of land, which is not very clear. Here, we have openly, we are getting mutation, we are distributing among ourselves, there is a family settlement, we are dealing with the property as if it is our own property. That is what I'm saying. These circumstances will be inconsistent with the requirement of this 2009 2 GLT referred in para 74 of the 24 of the judgment file. All these factors show that we are adversely possessing the land. That's my submission.
Heard Mr. D. Mazumdar, learned senior counsel assisted by Mr. Learned counsel for the appellant, and Mr. Ahmed, learned counsel for the respondent. Argument concluded. However, the recessal is the matter as parted as Mr. Ahmed, learned counsel for the respondent, submits that he will submit some case laws in support of his oral argument. Parallel recessal is the matter. Next week,
Lordship may make it CAB, he will submit the judgments, otherwise it's argument is complete. He may be permitted to submit 1 or 2 judgments tomorrow, day after tomorrow. The Lordship is not in any way going to pass the judgment in 2 days. So he
no,
will
that's
submit.
all right, but you submits that that copy of judgment will be has to be given to you so that you can reply.
Well, I will not reply, madam. Whatever I have argued, I have completed.
Okay, then all right. Okay,
Lordship may make it CAB.
okay.
All right, Lordship. Well, in the meantime, I will submit, Lordship.
Okay.
Pending item number 3.
All right, Lordship.
My lord,
Mm.
the last occasion that one petition
Mm.
that was filed.
Have you filed it?
Yeah, I have already brought it by filing an additional affidavit. In
Okay,
case
that
number-
additional affidavit is here.
Yep.
Bobby. Okay.
It is in
Yes,
page-
where is the petition?
petition is page number 120,
Mm.
120.
Mm.
This is type copy and the certificate copy is in the 122. There it is specifically mentioned, my lord, that the petitioner defendant who is in Manipur because of total disruption of railway and bus communication due to flood and landslide in Dima Hasao, Kasar district, he could not come to Guwahati to sign and swear the affidavits and Bhukalatnama as such. Under the compelling circumstances, the petitioner engaged counsel prays for adjournment of the suit and mistake for today and refix another date for filing of the written statement and written objection in the above noted title suit number 5 of 2022 and Miss J case number 7 of 2022 in the interest of justice and obedience. But this petition was not considered only on the ground that 90 days is over.
Okay, we will pass the order.
My lord, in this regard, there are Supreme Court authority as well as our own High Court's
No,
decision.
not necessarily.
My lord, deeply. Pending item number 17, fix that copy. Now, the list of witnesses there. Photocopy of Restore witness.
Lordship, my senior had to leave as she was not feeling well. She
Mm,
was here, she just had to leave.
mm.
Lordship, may kindly adjourn the matter for the day.
As prayed for by Miss
And Sultana.
M. Sultana, learned counsel for the accused. Recess shall list the matter.
So 19 or 20.
20.
Whether this list is part of the
Yes,
final
sir.
complaint.
It is a part of the final.
Standing item 5.
My lord, husband of the petitioner, my lord,
Mm,
at Pandit, my lord of Vivekananda High School, my lord.
mm,
He worked there, my lord, from the year 1969 till his death, 1992, my lord. And pay scale was also given by the, my lord, that at that point of time. Here, your lordship is, and Secretary, Primary Education Board, Karbi Anglong District Council.
mm.
So, my district council provided the benefit. It was also, my lord, increment was also given, my lord. Subsequently, my lord, I have, my lord.
Where,
filed one edis-
from where it is available? Page
Lordship,
number?
Yes, my lord, that is, my lord, service book page, in repetition, my lord,
Mm.
page 17, my lord, onwards. Relevant portion, page 19. And to, my lord, it is 22. 24. Okay. And records were, my lord. Petitioner applied for appointment letter, etc., my lord, all papers, my lord.
Mm,
But I have filed one additional affidavit.
mm,
An additional affidavit, it was filed on, my lord, 18/11/21,
mm,
wherein Bokazan Police Station mentioned there one certificate issued
mm.
that records were, my lord, during the, it was founded the true but not found clue and miscreants or stolen booties. There was a case also, my lord, page 5 in the said additional affidavit.
Mm,
It was, it is mentioned that this is to certify that 1/6/2005, complainant so and so, headmaster, Vivekananda LP School, Lords and Azahar, Bokazan PS, to the effect that in the night of 28/5/2005, some unknown miscreants entered in his office room.
No,
of
on
the-
the other day you have pointed out.
Yes, my lord.
Mm.
Already, I have already pointed out.
Mm,
Subsequently, my lord, I have filed one additional affidavit, wherein, my lord, I have specifically mentioned, my lord,
mm,
regarding the judgment which are covered my case, my lord. It was passed, page 10. It was additional affidavit was filed on 23/6/22,
mm,
wherein, in the judgment on order, I have annexed here, page 10. The period, my lord, is mentioned that petitioner who retired as a school teacher in the month of December 2003 has approached this court seeking a direction for counting his service rendered under the Dan Mikir Hills, now Karbi Anglong Autonomous Council, during the period 66 to 79 for the purpose of computation of his pension. The petitioner, it may be noticed that had served upon the district council during the aforesaid period until, at his request, he was transferred to a school Nagaon Plain District in the year 1979. Thereafter, after rendering service up to 2003, he was superannuated. Having regard to the nature of the grievance expressed, this court had required the Learned Standing Council Education to apprise the court of the stand of the government in the matter. Pursuant to the said order, the Director of Elementary Education Assam has submitted written note which has been placed before the court. On due consideration of the note submitted by the Director of Elementary Education, it appears that there is no tangible or reasonable basis disclosed which would warrant
exclusion of the period of service rendered by the petitioner under the district council for the purpose of computation of his pensions. In fact, apart from the several correspondence exchanged in the matter, without any final conclusion being reached till date, no other significant fact has been reflected in the note submitted by the director so as to justify the exclusion of the aforesaid period. On the contrary, in the note submitted by the director, there is a reference to some other cases which are similarly situated where period of service rendered under the district council have been taken into account for computation of the pension. In view of the above, I deem it appropriate to close the repetition at the motion stage by directing the pension of the petitioner will now be computed by taking into account the period of service rendered by him under the district council, and the entitlement of the petitioner to pension will be finalized by all the concerned within a period of 4 months. Thereafter, my lord, another order was also passed, Annexus C, page 12, my lord. Next page. It was followed the same principle, but here specifically mentioned, because prior to the 1974 Act, my lord, this Provincialization Act, there was another act, my lord, earlier, and in the said act, specifically it is mentioned. This provision has been mentioned, paragraph 9, my lord. This, my lord, page 13. Above part, I may also gainfully refer to the provision of the Assam Elementary Education Provision Act 1974, the Assam Elementary Education Provision Service and Conduct Rule 1981. Section 2 of the 1974 defines recognized school as a school recognized or deemed to be recognized under the Act, referring to the then existing board. Section 2N defines the state board for elementary education registered Elementary Education Act 1968. Section 2O defines existing teachers as teachers appointed or deemed to have been appointed by the government and the state board for elementary education under the Assam Education Act 1966. Section 3.3 of the Act provides that all teachers of elementary school and pre-primary schools maintained by the regional boards of elementary education constitute to be the employee of the state government. Section 351 provides that all the teachers appointed by the regional board of elementary education taken over by the government under section 3, subsection 3 shall be entitled to such scales of pay and also allowances as admissible to teachers of corresponding rank in the government institutions. Section 6 of the Rule 1981 provides that teachers shall be entitled to pension, gratuity, and other pensionary benefits as admissible to the government employee. The teachers who opt for pension scheme will discontinue their CPF contribution and open fresh GPF account and deposit the account of their own CPF contribution along with the interest.
All right, all right.
Yes, madam. Specifically, this.
Yes, so who is for elementary education?
Yes, madam.
What is the extent of the government? On the other day, Mr. Talukdar has taken time to obtain instruction.
We have much role. We
Pardon?
won't have much role, my lord.
Pardon?
We won't have much role, my lord. It's a transferred subject, my lord, because the pension,
Hmm.
the DO transfer is direct to the pension department, my lord.
Hmm.
So state, my lord, the commissioner and secretary and director will have no role here.
No rule. Yes,
Sir.
what is the extent of the council?
Well, to get the pension, the teacher must have the service of the state government pilot.
Hmm.
In this particular case pilot,
Hmm.
the service of that particular school,
Hmm.
of that school was provincialized in the year 2000,
Hmm.
my lord. In the year 2007.
Hmm.
Lordship, look into, my lord, my affidavit, my lord, that is page 56, paragraph 6.
Yes.
That Assam Elementary Education Provincialization Act 1974 was enacted by the government of Assam for provincialization of the services of the teachers and employees of the elementary school. Section 1(2) of the Act provides that the Act is extended to the whole of Assam except the Autonomous Council district, provided that the governor may, with the consent of the district council concerned, extend all or any of the provisions of this Act to all or any of the autonomous district on such day or dates as may be notified in this behalf. In exercise of the power conferred by Section 1(2) of the Act, the governor of Assam, after consultation and with consent of the Karbi Anglong Autonomous Council, extends all the provisions of Assam Elementary Education Act 1974 to the Karbi Anglong Autonomous Council with effect from 1/8/2003. That is the Annexure 1, my lord. The provisions of the Act applicable to the Autonomous Council with effect from 1/8/2003. Then the next notification of the Government of Assam, that is paragraph 7, that in pursuance to the government notification dated 8/8/2003, the Governor of Assam provincialized 1,411 number of LP school with 2,859 number of LP school teachers with effect from 1/8/2003 to facilitate to open the GPF accounts and to get other financial benefits like other provincialized teachers. The notification stipulates that in future, the provincialization of Assam Elementary Education Act will be applicable in terms of office memorandum dated 31/12/1996. This notification, my lord, issued in pursuance to the resolution adopted by the Assam Legislative Assembly, transferring the subject, that is primary and secondary education, to the Autonomous Council. The notification dated 26/6/2007 was issued by the Commissioner and Secretary to the Government of Assam. Then, my lord, that is Annexure 2, that notification. But the third notification is important, paragraph 8, that the Secretary to the Government of Assam Education Department issued a notification dated 6/10/2009, by which 340 number of retired, expired LP school teachers were provincialized, who had been working from 1/1/95 to 31/7/2003, on condition that pension, family pension is to be given not for other pensionary benefits with effect from 1/8/2003. The arrear salary from 1/1/96 to 30 are not entitled by the retired families, expired teachers, as they have submitted an affidavit in that regard. Lordship may look into the Annexure 3, page 63, that notification. In continuation of the department notification dated so and so, the Governor of Assam is pleased to accord approval provincialization of service of 343 number of retired, expired of LP school teachers of Karbi Anglong Autonomous Council as per list enclosed. The 340 number of provincialized retired, expired LP school teachers are within the 2,859 numbers of provincialized posts pertaining to 1,411 numbers of provincialized schools. The services of 343 numbers of retired, expired LP school teachers are provincialized who had been working from 1/1/95 to 31/7/2003 on condition that the pension, family pension is to be given not only for other pensionary benefits with effect from 1/8/2003. That is the date from such which the 2,850 number of posts are given the benefit by government notification dated 26/6/2007. The arrear salary from so and so date are not entitled by the retired families, expired teachers, as they have submitted an affidavit in that regard. So, my lord, the husband of the petitioner, my lord, died on 12/7/1992. So, before giving effect the order of provincialization, the husband of the petitioner died. And as per the government notification, my lord, the school was provincialized in the year 2007 and effect was given from 1/1/95. That without provincialization of the service of the husband of the petitioner, whether the petitioner is entitled to the family pension. That is the point, my lord. And it is the prerogative of the government regarding provincialization, and the act itself provides that government may fix a date to extend it to the Autonomous Council. And as per the, my lord, Article 244 of the Constitution, my lord, that is for administration of tribal areas, as per 6th schedule. And the 6th schedule provides the lawmaking power to the Autonomous Council in respect of primary and secondary education. When we have made the law Autonomous Council, the Central Act and State Act is also not applicable, my lord, to the Autonomous Council. There is a paragraph 12 of the 6th schedule to the Constitution of India. And the exercise of the power, administrative power, was given to the Autonomous Council from.
And that's all right. There is no dispute about it.
My lord.
To
get the pension or family pension, the concerned employee must be in the state service. And if the person is not in the state service, whether he is entitled to the pension or not.
Then how he has received the salary, from which fund he has received the salary?
That is, my lord, appointed, his appointment, if your lordship look into it, the service book is with the petitioner, lordship may peruse its service book. Let us look into the service book.
Yes.
Service book, my lord. Well, this is the original service book. The service book should be with the my lord appointing authority. And the petitioner submitted an affidavit to the extent that all the records were burned. But the original service, which was produced before your lordship, that is the original service book. It is with the my lord petitioner. Petitioner submitted before your lordship the original service book. But the affidavit submitted by the petitioner to the extent that all the records were burned. And the service book should be with the my lord appointing authority. But it is produced before your lordships today. So, my lord, if the service book is with the petitioner, to process the family pension or other pensions, it is required to be processed through the office. And if it is not with the appointing authority, it cannot be processed if the petitioner is also entitled. If the petitioner is also entitled, if your lordship holds that the petitioner is entitled to process the application for family pension, the service book is the utmost important, that is required to be produced. But the petitioner himself submitted in the affidavit that all the records were burned, but this original service book has been produced before your lordships. What is meant, lordship may interpret it like that, my lord. And regarding, my lord, application of the 1968 Assam Elementary Education Provincialization Act 1968, there is a provisions of constitution of board by the state government. And in that act itself also provides that that act is also not applicable until and unless government issued a notification to that extent. And in the 1974, that particular school, Vivekananda LP school, was provincialized. The other teacher service were provincialized in 1195 by order in 2003. But the petitioner was not in the service, so his service was not provincialized. All the other teachers, Vivekananda LP schools, who are serving at that time also.
When it was provincialized?
Well, it is provincialized 2003, my lord. That is annexure 1 of our affidavit. There is annexure 2, my lord. Page 62. The effect is given from, my lord, that elementary education came into effect to the Autonomous Council on 8 August 2003. That is a vital date, my lord. 8 August, annexure 1, page 61.
When the governor has extended that benefit?
That 26 June 2007. 26 June 2007. And it came into effect from 1/4/1995 when the memorandum understanding was, my lord, accorded by the central government with the groups, my lord, Karbi Anglong Autonomous Council. And the schools were provincialized.
1/4/19?
1/1/95, my lord. The effect was given from 1/1/95, my lord.
And this notification also does not cover his case.
My lord, this case, my lord, died here, as he died on, my lord, is an unfortunate case, my lord. The husband of the petitioner died on 12/7/1992, my lord, while he was in service. It is an unfortunate case, and it is a lordship's, whether lordship can exercise his discretion under Article 226 in the exceptional circumstances, your lordship. But the school is required to be provincialized, and benefit can only be get after the provincialization. So before the Provincialization Act came into effect, how it can be petitioner get the benefit? That is the submission. That submission has not yet been made. But there is submissions on that, my lord. Petitioner may submit, argue on that point without provincialization, how the petitioner can get benefit of the pension. The petitioner can assist also, my lord, on that point, particular point. That is the point, my lord.
Yes, Mr. Das.
My lord, so far, my lord, my learned senior argument is concerned, my lord. Here, my lord, this incident is prior to the, my lord, date of the fixing the date of the provincialization. Earlier also, it is, my lord, some such type of similar employee got their pension, etc. But here now, my lord, in this,
I have not, my lord, clarified the judgment referred by earlier judgment referred. On those cases, my lord, they were transferred for the council to the Plains area, Nagaon district, where the act is applicable. But at that point of time, Honorable Court decided that the benefit that render the service in the Autonomous Council, they should get benefit. They were transferred from the Autonomous Council by the government to the Nagaon district, by law. So they are getting the benefit, and Honorable Court directed to grant the pension and asked to count that period of service when they return in the when they serve in the Autonomous Council. But in this particular case, without provincialization of service, the person died, and in those cases they served in the Plain district and they retired after superannuation, my lord. So the entitlement of the pension and rendering the service, it is required to be counted in the judgment on that point, my lord.
My lord, page 14, my lord, in this judgment, first I want to place, my lord, what is mentioned, my lord, page 14. In my additional affidavit, the Honorable Court observed that paragraph 11, petitioner while was serving under the KAC was transferred to provincialized school in the district of Nagaon 91. He was never apprised that his earlier service would stand altogether obliterated. If the service of the petitioner's husband rendered under KAC is not countable, it is not understood as to how he could be transferred from KAC to provincialized school in the district of Nagaon. It is specifically mentioned, considering all the above aspects of the matter, it is hereby provided that the petitioner husband was entitled to count the period of so-and-so rendered in case of
No,
the
that's
pension.
all right. In both these cases,
Yes,
the petitioners were transferred from Karbi Anglong Autonomous Council
yes, my lord.
from the districts of Karbi Anglong to Nagaon district.
Yes, my lord. Now, my lord,
And that to a provincialized schools. But in your case, you remain there, and your school was also not provincialized. In
Then-
that case, how can this court can help you?
because that period, my lord, that period already earlier period. And apart from this, my lord, assuming but not admitting here, my lord, I have seen, well, there is a specific provision in the pension act, special, my lord, provision, my lord. Special provision is specifically mentioned, there is a judgment also, but it is mentioned, if any doubt arises, my lord, pension act.
Okay.
Yes.
Okay, you show me the book.
Yes. Page 233, 310, my lord. Hmm? 233, if any doubt arises as to the interpretation of any of the,
Pension Act.
yes, my lord, pension.
Yes, section.
Section, my lord, rule, my lord, that is rule, 233. Removal of doubt. If any doubt arises as to the interpretation of any of these rules or about the applicability of any of these rules in case of any person governed by the rules in Assam Pension Manual, second edition so and so. Immediately before commencement of these rules, the matters shall be referred to the state government in the finance department, who reserve to themselves to the right of changing the rules and interpreting their meaning, and whose decision therein shall be final. Rule 30, special provision, 234. In any case in which a pension is not admissible under any specific provision of any of these rules, the governor may sanction the grant of pension in exceptional circumstances if the grant is not consistent with the general spirit of the rules. That means 234, my lord. And 235, the governor of Assam is satisfied that the operation of any of these rules causes undue hardship in any particular case, he may dispense with the or relax the requirements of the rule to such extent and subject to such condition as he may consider necessary for dealing with the case in a just and equitable manner, provided that the case shall not be dealt with a manner less favorable than provided in these rules. So that deals with judgment, my lord.
As per this rule, the power is with the governor.
Yes, my lord, governor.
In that case, you have to file one representation to him.
Yes, my lord, giving that liberty.
In that one, judgment was given, my lord, Honorable Justice Soumitra Saikia, remit a discretionary power to exercise discretionary power. In our cases also, Cardiac Autonomous Council, the judgment was there. The discretionary power for pension in governor, petitioner may approach the governor or through the state government for relaxation of the rule.
Yes, ma'am.
That is the provision is there.
So then we are disposing of this petition,
My lord.
granting liberty to him to approach the governor
In
as per this rule 235.
My lord.
Yes.
Only, my lord, that the Assam, that in the provisions, if the lordship will look into the act, my lord. It was-
No, Assam Service Pension Manual.
No, my lord, Assam Elementary Education Provincialization Act 1974. That is important. That why we could not provide, the government could not provide the case 284, my lord. এখন কি আপনি?
Page
284. My lord, section 1, this act we call Assam Elementary Education Act 1974. It extends to the whole of Assam except the autonomous district. Provided that the governor may, with the consent of the district council concerned, extend all or any of the provisions of this act to all or any of the autonomous district on such date or dates as may be notified in this behalf. And that notification was issued in the year 2003, my lord, Annex 1, my lord. So it came into effect to the autonomous district only in the year 2003. And the husband of the petitioner died in, my lord, 1992. So the discretionary power, he can file the petition before the governor, to the Secretary of Education, and the governor will consider it, my lord.
Okay. That judgment passed by coordinate bench of this court is
Yes,
available.
My lord, my lord.
But here the matter was referred to this Karbi Anglong Autonomous Council for grant of adequate financial relief.
That is not the judgment, my lord. There is another judgment is there for discretionary power. To exercise discretionary power, my lord. If I can place the judgment, my lord, not now.
Yes,
Tomorrow I'll place.
Tomorrow you can give.
I will place it, my lord. That judgment, my lord. I think he has placed that judgment, particular judgment. He was the counsel in that particular, he is the counsel in that particular case. And it relates to autonomous counsel that regarding exercise of the discretionary power. What he has argued lastly.
Okay,
Tomorrow I'll place it, I'll give it, my report is.
okay, we reserve the order then.
Malloy.
Yes. Heard Mr. S. Das, learned counsel for the petitioner, and Mr. J. Sotia, learned standing counsel for the Karbi Anglong Autonomous Council, and Mr. Kaushik for the Director of Elementary Education. Argument concluded, order reserved. None appears for the respondent number 4. কিতাপ লাগিব কিতাপৰ
Item number 7.
With the consent of the other side, if possible, some other deal also.
Mr. U.B. Sharma, learned counsel for the appellant. Matter on 2015 matter, we'll fix it that when
Lordship, in the month of January,
Yes, sir.
possible last part of
December, after 9,
last part.
17 December,
Lordship, if possible, on 19. And on 17, I will be out of station.
19
Okay, all
December.
right, 19.
Oblige, Lordship.
Item number 8.
Please, your lordship. If I am the dependent and appellant hearing, lordship, I have checked the LCR, lordship. In their lordship, the exhibits are not there, lord. Documents are not there, exhibited documents are not there. C1 file. The LCR is there, but the documents which are exhibited are not there. There's a flag mark, lordship, blue flag mark. List is there, but documents are not there.
In this case, there was a previous title suit. The records of the previous suit was called for and was exhibited in this case. Your Lordship. Title suit 8/2007. Most probably the records of 8/2007 were transmitted after conclusion of this suit.
After?
After conclusion of this suit, the records were not kept intact with the current LCR.
In fact, in the list it is written also.
8/2007. I have some urgency in this case, Your Lordship.
They have some
No,
urgency. I have-
that's all right, but without the documents, can we hear the matter?
Lordship.
Hmm?
One thing, Lordship may peruse order dated 2011-2015 as regards the substantial question of law. The documents and the LCR will be necessary if your Lordship pleases to overturn the concurrent finding that is against them, Your Lordship. Perhaps the substantial question of law that was framed on 2011-2015, whether the finding of the learned courts below that plaintiff have acquired right by prescription under section 25 of Limitation Act 1963 can be addressed by merely looking at the judgment, Your Lordship. This is not a substantial question in my humble submission. Your Lordship. The issue number 5 was decided in my favor as the plaintiff by the trial court, and concurrently it was upheld by the trial court, appellate court, first appellate court. Is clear regarding section 25 of Limitation Act. I can
Okay, at the time of hearing, we may recast the
Lordship,
substantial question of
he
law.
is having some urgency, Lordship. I have taken some of the documents from
Given a
him.
photocopy.
So I can argue the matter, but not today, Lordship. Today I have received those documents.
Some other day it can be hard.
Okay, then if without the original document, no, original record, we can argue the matter, you can argue the matter, all right?
We'll try, Lordship. If necessary, other
Okay. Heard, Mr.
D. Chaudhary.
D. Chaudhary, learned counsel for the appellant, and Mr. P. Mukherjee, learned counsel for the respondent. Mr. Chaudhary, learned counsel for the appellant, submits that the matter may be listed for hearing on suggested that
On 7th January.
December, if possible.
December, so many cases, Lord.
Lordship,
last part,
in this case, early hearing was already allowed in 2013.
2013.
2023, sorry, in 2023, but it's not taken up. for
On 19th December.
Okay.
And number 9.
Matter may kindly be adjourned for today.
Lord, from my side, I am ready, my lord, to argue the matter. And there is an order, my lord, last order, my lord, let me see.
2nd April, I have to read the division
Lord,
also.
in the last occasion also, my understand has took time.
Lordship, it is.
But today time may not permit us. See,
So next Tuesday, my lord.
next Tuesday.
Lordship, it is not that 2017 matters.
No, my
It's
lord.
before this court.
This honorable court, after hearing the injunction petition on the instance of him, my lord, this matter was fixed for hearing, my lord. Because there was an injunction petition,
That is
and I
the
have filed
problem. He
objection.
wants to talk many things. He wants to
No,
talk
no.
many things. Problem is that.
Now he is wanted to linger the matter. After availing the injunction, my lord.
Okay,
Injunction was decided by very honorable court.
Kobe. So next week, we may try.
My lord.
May try.
19th.
21.
21.
As prayed for by Mr. Bhagavati, learned counsel for the appellant, raises and lays the matter on 19th,
On 21st. On 21st.
21st, 21st.
Item 10.
May I please, your lordship? Well, counsel for daughter is coming, my lord. He has asked me to allow me to process them.
Who is? For the other
Will
side?
take, my lord. It's coming, my
Pardon?
lord. The instant, my lord. The second thing, my lord, is against the concurrent findings, my lord. And for the plaintiffs, my lord. And here, my lord, both the courts below, my lord. While passing the in judgments, my lord. First of all, my lord, the admitted facts on the part of the defendants is absolutely overlooked or discussed thoroughly. And secondly, my lord, the material evidence exhibits all these things not discussed. And finally, my lord, here there's some legal provisions of law involved in this matter, my lord. Unregistered child, my lord. The defendants claim their title relying on the unregistered child, my lord. And both the courts, my lord, first trial courts discuss something, my lord, but not on legal point, my lord. Decreed against me, my lord. But appellate court, my lord, lordship find and lordship get surprised, my lord. Most casual, my lord, the appellate court has discussed and not even single point whispered so far as legal issue involved here, my lord. First of all, my lord, in this case, this honorable court on 16 November 2021 framed 3 substantial questions of law, my lord. Then I will take your lordship to the interim judgment. And for lordship's convenience, my lord. My lord, this is the, I'll take your lordship. Then first question of law, my lord. Whether the courts below were justified in dismissing the suit of the plaintiffs without taking into consideration paragraph 11 of the written statement
filed by the defendants wherein they have duly admitted that the Schedule A land belonged to both Boli Sheikh and Shadu Sheikh, who were admittedly the predecessors in interest of both the plaintiffs and the defendants. Number 2, my lord. Whether the courts below were justified in shifting the burden upon the plaintiffs to disprove the allegations made by the defendants.
Mr. Decker, what is this?
My lord, I have the facts, actually substantial question of the answer I have prepared. I will take your lordship later, my lord. The family history of the both the sides, my lord, I have one graph made, my lord. Here the whole disputes involved the total land 18 bigger 1 cut 3 lessons, my lord. Lordship will find in plaintiff side and defendant side. Plaintiff predecessors, my predecessor is Boli Sheikh, here, my lord. And the defendant's predecessor Salu Sheikh, they are brothers, my lord. Accordingly, my lord, out of 18 bigger 1 cutter 3 lessons, equally we entitled 9 bigger half cutter 1.5 lesser equally, my lord. Since we have filed the instant title, so for the right title, interest, lord, and
no, both are brothers.
Yes, my lord, our predecessors, my lord. Boli Sheikh and Sadhu Sheikh, my lord. And accordingly, my lord, the instant title suit we have filed right title, interest, and confirmation of joint possession, my lord. And number 2, my lord, apportionment of share of the parties. This is a question of law in our plain, my lord. But accordingly, my lord, what happened, my lord? In the 2007, my lord, the plaintiff, my lord, that is Ainuddin and Muharuddin, 1 bigger under doc number sold, my lord, to the pro forma defendant. That means, my lord, very next page, your lordship will find page number 2. That is B schedule land, my lord. After selling, my lord, after selling 1 bigger to pro forma defendants, the land remains with the plaintiffs. That is in our favor, my lord. That is 2.5 bigger so and so Boharuddin, 2.5 bigger so and Mohiduddin so and so. Therefore, after selling the land described in Schedule B of the plaintiff and defendants court, we entitled 8 bigger half cutter 1.5 and my defendants entitled 9 bigger half cutter 1.5. Admittedly, my lord, we have sold 1 bigger half land. I will come to later, my lord. Basically, my lord, the 3 substantial question of law, that means in paragraph 11 of the written statement, the defendants admitted, yes, both Boli Sheikh and Sadhu Sheikh admittedly their predecessors and they're entitled, both are entitled the equal parts share of the suit land, my lord. That is admitted because to ensure, my lord. It's on admission on fact. Number 2, my lord, since, my lord, they have raised that we certain portion of land we sold to some other person, other tenants, and from the tenants they again purchase. It is they have raised this issue, my lord. Since they have raised this issue that we some portion of land we sold to other tenants, from them they have sold, it is their burden. From when we have sold it and from them they have purchased this land, my lord. It is their burden, my lord. But border court below have not absolutely standing on this point. And for lastly, substantial question of law, they have absolutely relied that we are entitled the entire disputed land, suit land, relying on the exhibit K, L, M, N. These 4 exhibits they have relied, my lord. And these 4 exhibits, my lord, they have relied this is an unregistered shell deed. They're claiming title, relying on unregistered shell deed. These are the 3 questions of law framed by this honorable court. Now I'd like to take your lordship, the impinged judgment passed by the appellate court, my lord. In appellate court, lordship, you'll find the findings at case, my lord. Page 43. And my lord, the issues lordship will find at page 43. Page 43, the issue 8, my lord. The learned trial court has framed the following issues: whether the suit is maintainable, whether the suit is barred by law of limitation, whether the plaintiffs have the right title, interest, and possession over the land described in Schedule A, excluding the land described in Schedule B. Number 4, to whether plaintiffs entitled the decree is paid for and to what reliefs the plaintiffs entitled. Now, the number 9, points for determination. Whether the plaintiffs has been able to prove that the Schedule 1 land belonged to their predecessors and same is not partition. Number 2, whether learned trial court enriching the findings, erred in reaching the findings, the discussion, reasons, and decisions. 1, 1, and 2. This is a petition suit, partition suit. So in petition suit, one has to see whether the suit property is ancestral or joint property or not. Then the next one has to see whether there has been any partition or not. The plaintiffs claim that the first Schedule land that stood in the name of Ainuddin, Moharuddin, Shobar Ali, Kosharuddin Sheikh, Sona Sheikh. There are 4 branches of sharers in the Khatian having 1/4 share each, that is Ainuddin, Moharuddin, Moizuddin, that is the plaintiff's lot, and Sadhu Sheikh, that is the defendant. The defendants claim that there are 2 sharers in the Khatian, this is Boli Sheikh and Sadhu Sheikh, who were the own brothers. Number 14. The plaintiff side has exhibited the final Khatian 353 as Exhibit 1. And the same document is exhibited by the defendant side also Exhibit A. Para 4, serial number 14, my lord. Para 40, page 43. The plaintiff side has exhibited the final Khatian number 353 as Exhibit 1. The same document is exhibited by the defendant side also as Exhibit A. I have perused the same. The same are that there are name of Ainuddin, Moharuddin, both the son of late Boli Sheikh, Shober Ali, son of Moinuddin and Kosheruddin, and Sona Sheikh, son of late Sadhu Sheikh, that is Exhibit 1 and A. So it can be seen that the basis of the claim that there are 4 branches of sharer, this is Exhibit 1. If it is so, when a question arises that there are name of the 5 persons in the Exhibit 1, then why there are only 4 branches of sharers? The plaintiffs pleaded the Ainuddin, Moharuddin, Moizuddin were the own brothers, and each of them got 1/4 each in Acidul land, and Sadhu Sheikh got the rest 1/4 share in Fasidul land. If Exhibit 1 is the foundation document of the plaintiff's claim to Fasidul land, then each of the persons whose name are in the Exhibit 1 will get 1 share, which means the 5 persons will get 1/5.
No, what is Exhibit 1?
Exhibit 1 is the milot, is the Khatian milot. It's a Khatian number 353. We relied in that Exhibit 1 milot, our predecessors' named their milot, 18 bigha, the equivalent that we are entitled is 9 bigha, it is their milot. They also relied this as Exhibit 1 milot. Then milot 15.
Yes.
Next question is whether the scheduled land is not partition. PW2. PW2 will directly jump to PW2 without discussing the PW1. So far, this answer already answered by PW1 is evidence, but appellate court is directly on this point recorded only PW's evidence. PW2 Bachu Sheikh, the pro forma defendant number 1, said in cross-examination that the suit land has been partitioned among the plaintiffs and the defendants, but he does not know how much land was got by the plaintiffs and the defendants. So it can be seen that the plaintiffs with the PW's 2 has disclosed about the partition of the suit land. Under such circumstances, no question of partition arise. From above discussion, it is found that the plaintiff's appellant side had wrongly pleaded about the share of the Fasidul land. Again, the plaintiffs have failed to prove that there has been any partition earlier of the Fasidul land. If the joint property is not yet partitioned, then only the question of partition arise. In the memorandum of appeal, the appellant side had arisen the point that the respondent side could not prove the transfer of land to plaintiff predecessors by the valid document. The failure of the respondent defendants to prove their claim that predecessor of plaintiff had transferred the entire land of their shares to different persons is not material to entitle the plaintiff's appellant to get the shares in the ancestral joint property. The plaintiff's appellant have to prove their own case, and the case of the failure of the plaintiff appellant, we fail to get the decree. In our present case, the plaintiff appellant have failed to prove that the Fasidul land was not partitioned earlier. As such, I find that learned trial court has not erred in reaching the findings. Hence, I consider learned trial court rightly decreed the suit as no interference is required. The title appeal is dismissed. My lord, the judgment of all the relevant paragraphs I have read, my lord, neither discussed without the written statement, whatever written statement said by the defendants, neither discussed, my lord, that since they have taken plea that we sold some portion of land to the other tenants, my lord, and from them they have acquired that land, and even finally, my lord, the document
So,
they have.
can we remand the matter?
My lord? Yes,
Can we remand the matter?
this is a case of absolute remand, my lord. So I am
Yes,
praying.
Mr. Sheikh.
This is a case of absolute remand, my lord. Not discussed, because the most casually, my lord, that thing.
One thing I want to.
Come this side.
And if your lordship want to remand the matter, there should be either additional issue is to be framed by your lordship. One additional issue or 2 additional issue. And otherwise, my lord, your lordship is to find out whether any issue is wrongly decided. On two
No,
counts, my lord. Only
it
on-
appears that there is no discussion at all.
My lord.
Hmm.
So, my lord, in that case, my lord, on particular issue, if your lordship find that there is no discussion on this issue, so matter is remanded for addressing that issue, then that can be done. Either framing additional issue.
No, Mr. Sheikh, this under Rule 23A, Order 41,
Order 41, Rule 23A, my lord.
capital A. Remand in other case, where the court from where whose decree and appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal and retrial is considered necessary, the appellate court shall have the same power as it has under Rule 23. So this section, no, this rule does not want framing of any additional issue.
My lord, here your lordship will looked into dispose of the suit upon a preliminary point and the decree-
Otherwise than on preliminary point.
And the decree is reversed in appeal. If the decree is reversed in appeal, is a concurrent decree, my lord. It's a concurrent decree. So, my lord, may I read? Where the court from which decree and appeal is preferred has disposed of the suit upon a preliminary point, and the decree is reversed in appeal. Your lordship, in that case, your lordship is to reverse.
Otherwise than on a preliminary point.
Yes, my lord.
That preliminary point is the
court
requirement
from
of
which
Rule
decree appeal
23.
is preferred has disposed of the suit on a preliminary point.
No,
And
23 capital A. You are reading 23.
Hello. Remand the other cases. Where the court from whose decree and appeal is preferred has disposed of the same case otherwise than a preliminary point, and the decree is reversed. So, my lord, here necessity of reversing the decree is necessary. So,
Definitely, in order to remand the matter, we have to set aside the decree.
my lord, reversal will be necessary. That's all, my lord.
Definitely.
But your lordship, I humbly submit before your lordship that for reversal, my lord, some pronouncement of judgment is necessary.
We will discuss
Reversal,
the.
when the question of reversal is there, your lordship definitely will give a finding that this is the reason the judgment is to be given. That
Definitely.
Yes, my lord.
Definitely.
Yes.
So as submitted by Mr. Deka, the learned trial court has not considered
some witness,
some material witnesses and also documents.
And law as well as as well as law, question of law doesn't discuss below. Evidence, exhibits, nothing.
Always it is there, my lord, if the perversity is there, my lord, that is the substantial question of law. That is there. If your lordship finds that actually there was no discussion regarding certain material documents, regarding certain evidences on record, then definitely your lordship can interpret. I am not disagreeing with that point. But thing is this, my lord, your lordship will consider because it is a long pending matter and concurrent finding is there. Because my lord, as the concurrent finding.
Otherwise, can we dispose of the appeal on the basis of the materials available on the record?
Absolutely, lordship may. Lordship may. Either of this. Lordship, either of lordship on merit or your lordship may.
Instead of remanding the matter.
And since may not, and this may not, substantial question of, importantly, may not 3. Since it is evidence is necessary to discuss, my lord.
If your lordship want to dispose of the appeal finally, then my lord, scope will be very limited. That is the substantial question of law. on substantial question of law
yes.
only, that decree may be
We'll
interpreted.
hear on this substantial question of law.
That may be. And otherwise, my lord, what your lordship earlier pointed out, matter may be remanded back if your lordship finds it.
No, he has already agreed, but you have
No,
reservation.
I did not disagree, my lord.
Agreement.
My lord, I have not disagree with your lordship.
This
But
matter
thing
is of
this, my
which
lord.
year?
Yes, my lord.
Mr.
Matter
Deca?
is
My
very
lord, that was to the year of my lord, 2011.
11.
2011. My lord, about
If lordship gives some time bound direction, so that.
my lord,
Nowadays, we cannot give direction
Yes,
to the trial court to
Yes, my lord.
dispose of the suit within a particular period.
10 year minus, then also 14 years, and if it is 11, my lord, it is 13.
Let us do one thing. We will dispose of this matter here, not today. We will hear you on for a short data.
Lordship, short date. 3rd December. 3rd December.
Before 3rd of December.
28th.
28.
28th.
28.
28th of November.
November.
Yes, ma'am.
20.
My lord.
Or 27.
My lord, 27 is better.
27 Wednesday, Lordship. Hearing matter.
No.
No issue.
November.
27 November, Wednesday.
Wednesday. Okay.
26th.
28 is
26.
Thursday.
Thursday. Or
Hearing day.
26, my lord.
26 Tuesday.
26.
Any day, Lordship, Tuesday or Thursday.
26, 11.
26 November.
Okay. As agreed by learned advocates of both the parties, let's list the matter on 26
26th November.
at 2 p.m.
My lord. It's kept as part of.
Okay. List the matter as part of.
Leave the
You
list.
want to take this with
Yes, of
take
course.
this back?
Yes, my lord. Lordship.
But it is a right direction, my lord. Otherwise, what will happen? If your lordship remand the matter, 13 years already passed. Another 13 years will go.
That's
So remand also.
therefore I have
I think we
decided to hear
continue,
the
my lord.
matter here.
Let it set at rest.
Item numbers 11 to 14.
This four repetition correct, similar issue is similar. Issue is like that, my lord, the petitioners are the originally they are the assistant teachers of the upper primary schools. Assistant teachers, the science graduate teachers of the upper primary schools. They are getting the graduate scale of pay from their date of appointment. Now what happened, my lord, in respect of upper primary school, the post of headmaster, the post of graduate teacher, we are the same scale of pay. But the post of headmaster is a promotional post. The petitioners have been promoted to the post of headmaster. In the event of promotion, my lord, they ought to have been given the benefit, promotional benefit, one increment, at 3% increment of their salary, my lord. That is not given. And on the other hand, my lord, for serving for more than 30 years, the petitioners are entitled for otherwise MSCPS benefit modified for financial upgradation, my lord. Every 10 years, now as per ROP 2017, my lord, every 10 years, if there is no promotion or promotional scope of the employees, my lord, they are given financial upgradation, 3 financial upgradation, one at 10 years, one at 20 years, and one at 30 years of service, my lord. Whatever, my lord, the petitioners have been denied the promotional MSCPS benefit on account of, my lord, promotion. That you have been promoted to the post of headmaster. Therefore, you are not entitled to the MSCPS benefit. But MSCPS benefit is in lieu of promotion. If an employee doesn't get any promotion for a period of 10 years, 20 years, and 30 years, they are given the benefit of MSCPS. MSCPS is my financial upgradation. And if an employee gets the promotion, my lord, he is not otherwise entitled for MSCPS benefit. In the instant case, my lord, the petitioners have been promoted from the
post of graduate science graduate teacher to the post of headmaster. I'm going to the annexes later on, my lord. Just I'm giving the brief. And my lord, what happened? They have been denied on account of their promotion. They have been denied the benefit of MSCPS benefit. On the other hand, my lord, because they are getting the same scale of pay between the science graduate teacher and the promotional post of headmaster, my lord, they are not given the financial benefit, any financial benefit on account of promotion. Both the way they have been subjected to deprivation, my lord. You are not giving the benefit of MSCPS on account of promotion, and on account of for the promotion they are not given any financial benefit. Both the way, then the promotion is a curse for them. Otherwise, as per my lord, ROP, revision of pay rules, my lord, there is a clear provision for fixation. I'm giving it provision. My lord, clause 11, last. Fixation of pay on promotion on or after 1 day of April 2016. In case of promotion from one post to higher post on or after first day of April 2016, the fixation of pay of a government employee shall be made in the following manner. A. One increment equal to 3% term of the sum of the existing pre-promotion pay in the pay band and the grade pay corresponding to the pre-promotion post shall be computed and rounded off to the next multiple of ₹10. That means, my lord, pre-promotion and promotion post caters, my lord, same scale of pay, same grade pay, and same pay band for the post of graduate teacher of the ME school and for the post of headmaster of the ME school. Therefore, otherwise, I'm entitled for 3% of my lord increment, annual increment in respect of my original grade pay and pay band. This is the rules, ROP rules. This is governing the field, my lord. Now I'm taking your lordship to the writ petition. Page 54, my lord, your lordship will find in WPC number 4917. This is the ROP of 2010. Earlier ROP, my lord. Here you will find the headmaster, ME, MB, and senior basic. These are upper primary schools, where the grade pay band is 5200 to 20,200, and the grade pay is 2,800. And the same, my lord, graduate teacher science, senior basic schools, same scale of pay. Same scale of pay. This is the position in 2010, and thereafter, my lord, next page you will also find page 55. There was during the earlier ROP, my lord, there was an enhancement in the grade pay, 2,800 enhanced to 3,300.
Page number?
Page 55, last, my lord, table last line. Within the table last line, during the earlier period of ROP 2006, there was enhancement in the grade pay from 2,800 to 3,300. Then I take your lordship to page 56. This is the ROP of the present, it's running, my lord, 2017 ROP, 7th revision of pay, my lord. Headmaster, it has become 3,300, then it has become 8,000. Page 56, my lord. 8,700. Earlier scale has been revised. The pay band has
50,000. Oh, no, 57 page is the report of the anomaly committee. 57.
And Annex 3A, 56. Annex 3A.
Yes.
You will find revision took place from 5,200, 20,200, 3,300 grade pay to 14,000 to 49,000 pay band and 8,700 is the grade pay in respect of headmaster as well as graduate teacher. Same, my lord. This is the report of the anomaly committee. They have also, my lord, recommended that anomalies are there. Page 59. They have recommended, my lord, serial number 106. The pay scale of headmaster of middle school should be higher than the graduate teacher. Separate recommendation for pay scale given, but it is not implemented by it is not accepted by the government. But the position is that the scale of pay, my lord, for the post of headmaster and the science graduate teacher at page number 61. This is a notification published pursuant to the report of the anomaly committee dated 2nd July 2018. Your lordship will find page number 61. It is given 8,700 for ME, MB senior basic school. It is 8,700.
Page number
61. Man.
Graduate teacher 7,400.
Page number 61, my lord. It is below that MEMB. This is 4,700 for LP school, my lord. It is ME school, MEMB senior basic school, UP schools. Last column. You also will find in the right hand side.
Graduate teacher.
Yes, same 8,700. My lord, annexure 4, I have annexed only for that, just to, my lord, give an example. This is the provincialization order. Example, my lord, your lordship will find head mudaris, this is headmaster, grade pay is same 3,300, and the science graduate teacher, my lord, science serial number 4, it is 3,300. Headmaster and the science graduate teacher are the same, my lord.
Serial number
4. Graduate teacher intermediate science and mathematics, my lord, 3,300. And the head mudaris means, my lord, headmaster, 3,300.
Director, whether you have filed any representation to
It
the
is filed, my lord, it is rejected. It is filed and rejected, my lord.
On what
Representation
ground it was
Annexure 7,
rejected?
page 72. It is rejected, my lord. Rejected by the impugn order, my lord. I am taking your lordship to impugn order, page number 82. Annexure 9.
No, whether government has acted upon the
Representation
report
that-
of the anomaly committee.
No, my lord.
No.
After the anomaly, my lord, the anomaly committee has given the, my lord, a clear-cut picture that, my lord, for a graduate teacher and the headmaster, scale of pay should be 8,700 as per ROP 2017. And, my lord, thereafter, they have rejected, my lord, page number 9, page 82, Annexure 9, my lord. By communication dated, my lord, 30th August 2017. They have written a letter. With reference to your letter above, I am directed to inform you that there is no provision for benefit of 3% increment as promotional benefit to headmaster of the headmistress of ME, MB, MEM school who are promoted from science teacher. This itself is in violation of their ROP provision, my lord. ROP provision clause 11A clearly prescribes that in the event of promotion, my lord, from the feeder cadre, the 3% incremental benefit has to be given to the incumbent who have been promoted to the next higher level, my lord. That is, this impugn communication itself is in violation of their own rule, my lord. Thereafter, my lord, another representation was submitted in the year 2019, Annexure 11, my lord, page 87. After that, there was another impugned order, my lord, by the Commissioner, Education, my lord, page 89, Annexure 11A.
Page number?
89, my lord.
Yes.
Yeah. But done, this impugned order is done by the Education Department on the recommendation of the Finance Department. And they, in violation of their own rule, has given the wrong recommendation, my lord. I read, my lord, operative portion. In order, in view of the above, the matter was forwarded to Finance PRU Department, and it was decided that the post of Headmaster of Upper Primary School is a promotional post for the post of Headmaster of Upper Primary School. The feeder categories are assistant teachers and science graduate teachers of upper primary schools. Although science graduate teachers of upper primary schools draw a higher grade pay than assistant teachers, which is at present 8,700 and is equivalent to that of headmaster of upper primary school, the science graduate teachers or any incumbent to the post of headmaster of upper primary schools are eligible to draw the prescribed scale of pay along with special allowances as admissible. Special allowances, my lord, is an allowance only given to, even if it is given to the in-charge headmaster, only for buying in, my lord, contingency fund. It's like contingency fund. It's not as, it cannot be counted as a promotional benefit. They have taken a stand that they are given special allowances. Special allowance is not within the zone of basic salary. Basic salary includes the scale of pay and the pay band and the grade pay. Unless and until a benefit comes within the zone of grade pay and the basic salary, pay band, it is not a promotional benefit. It's a benefit. Special allowance is not a benefit. It's given 300 rupees only for purchasing chalk, duster, etc. Only for official communication, someone goes, it's like that, like 300 only. It is given to the in charge, who is not promoted even for LP school and for upper primary school. As per ROP 2017, madam, I'm reading the next paragraph. Headmaster of ME, MB senior basic schools, they are getting special allowance as per government notification number such. Therefore, though petitioners who are in a position of the science graduate teachers are not entitled to draw the scale of higher grade pay in view of the above, the claim of the petitioners has been rejected. They have violated their own service rules, own my lord, the guidelines given in the ROP. This is a 309 rule, my lord. Then I'm taking a lordship to Annexure 12, page 91. This is the MSCPS, my lord, guideline. It clearly prescribes that, my lord, during 10 years, one increment if no promotion is given.
No, in your case, you have been promoted.
Yes, we have been promoted. During 30 years, we have been promoted to the post of headmaster. We have been given 2 financial upgradations. But for account of promotion, we have been denied the benefit of MSCPS, which is we are entitled to. That we have been promoted. And in the event of while consideration of promotion, we have not been given the benefit of 3%. Promotion is therefore a curse to these categories of employees.
Go back to your original post.
That they are not doing, my lord.
Are you interested to go?
If they my lord, do it, I have no objection. Because 3% benefits they are taking away without any basis. Without any basis, they have promoted. As per their own, my lord, ROP, as per their own ROP clause 11A, which prescribes, my lord, in the event of promotion, you are entitled to 3% benefit over your grade pay and pay band.
In which part of the ROP it is provided?
It is
person.
It is given, my lord. I have just given the page, my lord. You also will find
page number
311. It is I've got the book, my lord. The clause 11, just I'm giving the 11 page I have given you. That says clearly one increment equal to 3% term of the sum of the existing pre-promotion pay in the pay band and the grade pay corresponding to the pre-promotion post shall be computed and rounded off to the next multiple of rupees 10.
No, you have enclosed that page. Yes. Page number 312.
312.
Okay.
This is the law, my lord. This is the book prepared by the finance department after being submitted by the pay commission and recommended and accepted by the government, my lord. This ROP has been formulated. 309 rule, my lord. All employees, this is applicable to all Assam government employees.
So you are agree for not giving this 3% of benefit?
Yes.
Yes, Mr. Gogoi.
Well, probably if he can show his prayer made in the repetition, then lordship will it will be clear whether that he was the 3% or he is agreed by them not having the same grade pay and the pay scale as that of a graduate teacher. Now after being promoted also he is enjoying the same grade pay, except that special allowance.
No, maybe it may not be, Mr. Gogoi, it may not be in the pair portion of the rate petition, but the court has the power to formulate the.
I understand. Sorry for that, my lord. So thus, my lord, he is in a line of argument now, my lord, he has made this statement that, my lord, where is that particular 3%? If that, my lord, particular page is given to me, at least I can, my lord, point out. My lord, 11. Lordship will see, my lord, the very first line, 11.1. Sub-rule 1. In case of promotion from one post to the higher post, on or after first day of April 2016, Lordship will kindly mark the word, the fixation of pay of a government employee shall be made in the following manner. My lord, the pay scale has been given in the ROP. With that particular pay scale, my lord, say, my lord, here, my lord, in the case of the present petitioners, in the ROP it has been given, so far as their, my lord, pay scale is concerned. It is, my lord, grade pay say 8,700 now. Earlier it was less.
Can the pay scale and the grade pay
now,
in the feeder cadre and also in the promotional cadre may be same?
It is, my lord. I have a judgment to that effect. The Honorable Supreme Court has held that, my lord, merely because a person is promoted, it is nowhere mentioned that, my lord, he will get a higher pay scale. Promotion cannot always be accompanied by a higher pay scale. My lord, is there. I will judgment, in fact, my lord, I can proceed right now.
Definitely. Then, as pointed out by the anomaly committee, why don't you accept it?
My lord, then also, my lord, I will, my lord, rebut, my lord, by citing a judgment of the Honorable Supreme Court. The Honorable Supreme Court has held, my lord, that pay commission are recommendations. It's not that, my lord, is binding on us.
No, you have accepted it and you notified it in the official gazette.
No, my lord, not the entire part. So now, my lord, if he is aggrieved by this, my lord, whatever grade pay or pay scale has been given to him in ROP 2017, my lord, you will have to challenge the particular provision in the ROP, my lord. And, my lord, ROP 2017 is a rule framed under Article 309. So you will have to challenge it, my lord. Without there being a challenge, my lord, can this Honorable Court, my lord, go into the arena whether, my lord, some petitioner has been deprived by, my lord, this ROP rule 2017? There will have to be a specific relief. Only then, my lord, this Honorable Court can go into or, my lord, give relief to the petitioner by striking down that particular provision. Where, my lord, same pay scale has been given. If at all, my lord, ultimately the case goes in favor of the petitioner. Today, lordship is yet to decide to hear us.
No, it is your own report, the committee, report of the anomaly committee.
Only anomaly committee, they only recommend, my lord. This is the finally.
No, that's all right, but you have to acknowledge that some discrepancy is there.
My lord, so far as the special part is, increment part is concerned, that has been finally provided by anomaly committee only, my lord. In 2010, there was a particular recommendation that it should be increased. But in 2017, there is no such recommendation. Otherwise, also, my lord, going by the judgments, my lord, being a report is Honorable Court under 226, Honorable Supreme Court has held, my lord, in a similar case, my lord, not actually similar, but relating to recommendation of the my lord expert committee or say like the other pay commission. Honorable Supreme Court has held that my lord, it is not binding. It's up to the state to see. Because they will recommend, but we'll have to see our financial condition and all, my lord, while accepting the recommendation. Every point, my lord, there has been
No,
recommended.
that's all right.
Yes.
But the question is whether it is not notified in the, it is 3% is notified in the official gazette.
No, that's why Lordship will kindly see the word fixation. That's why I'm saying, my lord. Say, my lord, say pay scale, say rupee 1 dash to say 10 and grade pay say rupees 12. Now that is the minimum pay scale, which has been prescribed in the my lord ROP. Now on that particular point, my lord pay scale, there will be fixation. It's not that my lord, whatever is written there, employee gets it. All these my lord, DNS allowance and all my lord, including this 3%, it will be added. Finally, he will get a particular sum, which will be higher than this particular pay scale mentioned here. In total SLA, yes. It will be inclusive of DNS allowance, inclusive of my lord, that
No, that's all right.
allowance.
That's
So
all
my
right.
lord, that figure is something, my lord, is the minimum.
No, Mr. Gogo, you say, in the event of his not promoted to the headmaster, post of headmaster, he would have entitled to this this MSCP.
One thing, my lord, here, my lord, by force, nobody has given promotion, my lord. His name along with others have been recommended. If he is agreed by that, my lord, he will have to, my lord, yes, he will have to, my lord, step down. Because, my lord, as my lord held by the Honorable Supreme Court, it's not always, my lord, that, my lord, it will be accompanied by a higher pay scale. Now he is, my lord, doing some higher responsibilities and all, my lord, considering his post. And then, my lord, 300 rupees, there is a provision that it will be revised. Maximum will be 500 or something. And my lord, that particular amount has not been given to buy chalk and all, my lord, or pen or paper for his own, my lord, office. It has been given to him as a special allowance. That statement is entirely wrong, my lord.
No, special allowance is only for him, not for person.
For my lord, this stationery is for the school.
That's
my
all
lord.
right.
That is a wrong statement, my lord. And there is a revision also. There is a chart, my lord. I will place it, my lord. There is a chart which we have annexed in our affidavit. That it will increase from 300 and highest is of course is 500. But that will have to be, that particular notification will have to be put to challenge that this is wrong. There is no such challenge herein. Even my lord ROP rule where it has been prescribed the same grade pay, that of the my lord graduate teacher, you will have to challenge it. Only then lordship can strike down that particular part and say that we'll have to reconsider it and my lord higher grade pay or higher pay scale will have to be given. Because it's the ROP rule, it has been passed by the legislature. Without there being a specific challenge, can this honorable court enter into that arena? Lordship may find that there may be some anomaly, but there will have to be a proper challenge to that. Only then proper relief can be given. Moulding is something which will be associated to the main prayer. But that cannot be a main relief, my lord. Always, my lord, Lordship can add some more, my lord, along with the main relief granted. But my lord, that cannot be the main relief. By moulding the entire prayer, the main relief cannot be given, my lord. There will have to be a very specific prayer, my lord. And my lord, it's a issue of my lord 309 rules. We are, my lord, following the rules only, my lord. And my lord, this particular 3% is the fixation, my lord. He will have to show the breakup that, my lord, this is the pay scale as on that he is getting, and this particular, my lord, component of 3% is not there in the scale of pay which as on that he is drawing. He'll have to show that, my lord. He will have to demonstrate before the honorable court that, my lord, that fixation has not been done.
Yes, sir. Whether the fixation formula is with you.
My lord, I don't know. Whatever my learned friend has submitted, my lord, is not actually correct. But let me clarify, my lord. He has made some confusion. My learned friend has stated that I need to challenge the ROP. I need not. Because the ROP has, my lord, given the prescription. In the event of promotion, in the same scale of pay, I'm entitled for 3%. Simple, my lord, provision is there. Why shall I go for challenging this, my lord? I need not. This is as simple as that, my lord. And my lord, page 91, this is the notification of the government of Assam, which says, in the event, suppose my lord, the two scale of pay in the promotional post and the feeder post are same, following the mandates of FRSR, FR 22, my lord, when there is the enhancement of the responsibility, I'm entitled to one increment. This is followed from the my lord, FR 22. This is, they have issued the notification dated 24 May 2024, page number 95. I have annexed. This is their notification. If my learned friend says, my lord, that I am following the rules, they should follow their own rules. They are violating their own rules, my lord, by giving the impugned directions that I am not entitled to any benefit in the event of promotion. This is their own violation. Fixation. When there is a promotion, there is of course a fixation. Fixation will follow from the promotion. And therefore, my lord, in the event of promotion, I am entitled to one increment as per clause 11. This is the issuance of the impugned direction that you are not entitled. The direction is issued to the treasury. You don't give. Therefore, even after fixation, it is deducted. It is not given. This direction itself and the issuance of the order by the my lord, the Education Commissioner on the basis of the recommendation of the Finance Department is absolutely wrong, my lord. Because allowance, there is a difference in the salary pay structure. Salary includes two structure, my lord. One is basic and one is allowance. Allowance, my lord, doesn't go on. It ends with the ROP ends. Basic structure, it carry forward. Basic, my lords, if the promotional benefit is given to me, it has to be within the basic pay structure. Otherwise, after my retirement, I will get benefit of pension, my lord, from the original, without original basic, unless and until my basic pay structure is increased, it is not a financial benefit. It cannot constitute a financial benefit. Promotional benefit has to come within the ambit of basic pay structure. Basic pay structure in this pay band system, my lord, pay band and the grade pay. It's a combination of two things, my lord. Pay band and grade pay combination, and over that, my lord, 3% annual increment. It goes like that. And that after retirement accumulates, my lord, as a basic pay structure. And the pension will determine, my lord, on the 50% of the basic pay structure, not including the allowance. Allowance will be deducted. Allowance will be, my lord, given up. When the pension of an employee will be calculated after retirement, it has to be after calculating his entire service benefit of the basic pay structure, not including the allowance benefit, my lord. Allowance is given, sometimes is special allowance, sometimes headmaster charge allowance. It is changing. After every 10 years when ROP comes, my lord, different allowances comes, my lord. It goes also. Again, new allowances come. Rates are different. It changes. But the basic pay structure will go on, my lord. Calculation provided in the ROP, my lord, absolutely basing on the basic pay structure, not on the basis of the allowance, my lord. Allowance is a separate part of the salary. It cannot be clubbed together. If someone is getting 50,000 salary altogether, it is not his entire salary. A basic pay structure is less than that. Salary will include allowances plus basic pay structure. Therefore, my lord, giving allowances would not amount to, my lord, financial benefit on account of promotion. Promotional benefit will come only when the 3% benefit is included in the basic pay structure. That will continue. That will not go even after ROP comes, new ROP comes, it will not go. It will continue, carry forward. That is the thing. My learned friend's submission is therefore not correct.
We see the prayer once,
prayer we have put to challenge the impugned order itself.
Let me point out, page 35. What you will see, page 35 of WPC 4917, 2021. 4917, 2021. It says, my lord, page 35, in the premises aforesaid, it is therefore great that your lordships may be pleased to admit this petition, call for the records, issue a rule calling on so and so, and the direction should not be issued by setting aside and quashing the impugned order dated so and so. That is a speaking order. Issued by respondent number 1 by declaring the same as illegal, null and void, and unsustainable in the eye of law. And further, your lordship may be pleased to direct the state, now lordship will kindly note this, direct the state respondents to enhance existing pay band or grade pay attached to the post of headmaster, headmistress or upper primary school as per recommendation dated 31/12/2017 given by the Pay Anomaly Committee, constituted by the government subsequent to enactment of ROP 2017 on the basis of recommendation so and so, so and so. Now, lordship will see finally what is the ROP at page 56.
My lord, another pair is there, MSCPS. There is not complete.
Pay band and or grade pay. Page 56. Lordship will see the revised structure, page 56, this is a part of the ROP of 2017.
Yes.
You will see the highlighted part, Assam Lower School Service, Teaching and Inspection, ME, MB, Senior Basic Schools, Headmaster. Lords, you will see, first part is the ROP 2010. Now, the next part is the ROP 2017. That is the revised part. Lords, you will see in 2010, for Headmaster, it was PB means pay band 2. The pay band 2 with grade pay of, with the pay scale of existing pay structure of 5,200 to 20,200, and the grade pay was 3,300. And for graduate teacher at that point of time, it was 5,200 to 20,200. But there is a difference of side lower for in the grade pay, that is 2,700. So there is a difference at that point of time in 2010. Now in 2017, it is in the revised part, it is PB2, that is payment 2, and the scale is pay structure is 14,000 to 49,000. And the grade pay is 8,700 for the headmaster. Now, graduate teacher, it is same. In 2010, there was a difference. The grade for graduate teacher, the grade pay was 2,700, and for the headmaster, it was 3,300. But this time in 2017, it has been made same. Both my entire pay structure is same. So that's why that special allowance has been given. Now he wants that this should be modified in commensurate with the recommendation made by the Pay Anomaly Committee. By not accepting the Pay Anomaly Committee's report, this ROP has already been published. It has been passed by the legislature, the assembly. So you will have to challenge this, first part. Now coming to the second part, the third part of the prayer. This is the second part. First is the impugned speaking order. And to grant benefit of promotional increment, so and so. Now, increment will be added to this 14,000. Lords, you will see, just may I arithmetically point out, minimum of the pay scale will be 14,000 of a headmaster plus 8,700 minimum basic pay. It will be 22,700. Now, on this, the fixation will be there. Various revision will be there. Like I have stated, DNS allowance will be added. House rent allowance will be added. Medical and all will be added. And including this 300 or 500, whatever is receiving as a special allowance, that will be added. Including this yes, annual increments, that 3%, that is called fixation. We can fix some additional part only when there is a base level is given. This is the base level, So to say that he is not receiving anything under the rule 11, he'll have to demonstrate that this is the base scale I am getting, and these are the benefits that have been given to me. And in this benefit prescribed in rule 11 has not been given. It's up to him to demonstrate before the honorable court. Only then you can reply.
That I have already demonstrated, my lord. Impugned order itself reflects that you are promoted, you are not entitled. Impugned order itself reflects what my learned friend is submitting, my lord, is out of the record. Impugned order itself says that you have been promoted, you are not entitled. What more is required for demonstration, my lord? My fixation is done without giving the promotional benefit, implies it from the impugned order itself. There doesn't arise any further demonstration. And in the prayer, my lord, I have given the MSCPS benefit. In the alternative, I have given the MSCPS benefit. Prayer, clearly I have made in the prayer, page number 36, my lord. Following the mandates of FR 22, they have issued the office memorandum. The memorandum is there, page number 91, that if the promotional post and the feeder cadre post, my lord, bears the same scale of pay and pay band, my lord, in that event I am entitled for 3%. As simple as that, my lord. Otherwise, I am entitled to MSCPS, third MSCPS benefit for completing the 30 years of service. And my lord, my impugned order says that I have not been given. What more I can give for fixation, my lord? Fixation is done. Whatever I am getting, my lord, without the benefit of promotion. What I was in the cadre of graduate teacher, that is continuing. That is implied. And fixation, what my learned friend is saying, my lord, is not like that. When there is promotion, there will be fixation. But here, for not to fix my salary.
One thing, you produce the latest salary slip.
Yes, with the breakup, with the breakup.
With
Then
the
at least
breakup.
I can have the instruction from my department that to whether it is getting or not. At least I can have the instruction at that point of time. Let him place the salary slip with the breakup. Last salary slip.
When you will be able to produce it?
1 week time will be given.
1 week time.
And date will be given.
Heard, Mr. A.K. Dutta?
B. Purgasto.
B. Purgasto, learned counsel for the petitioner, and Mr. Gogoi.
Final paper.
Council, Learned Standing Council for the Finance Department. Respondent number?
My lord, there are three cases or four cases. Lordship will only say, my lord, for the finance department.
For the
Because I am
Finance
there in
Department.
all
And Mr. Kosik?
11, 1, 3 and
1 and 3.
1, 3 and 4.
1, 3 and 4. 1, 3 and 4.
cases.
List the matter on COVID next week.
December, 5th December.
No, 1 week. Let him.
Yeah, at least let him produce.
So that he can obtain instruction again.
26th November.
Well, 26 November. List the matter as parted.
Blinders.
Room number 16.
May it please smile. This civil revision petition is filed against the judgment and order passed by the special tribunal in the land grabbing case, madam. Perhaps today, madam, already.
Time may not permit.
My lord.
So in the month of December, this is 23 matter.
23 matter, madam. I have got no urgency.
January. First week of December.
Last week.
First week of.
First week not possible. Oh, okay. First week.
First week in hearing day, my lord. Why? Because I am suffering.
On the, as agreed by learned advocates of both the parties, recess and list the matter on 5th of December.
5th December.
5th of December.
5th of December. Item 18.
Last one. Yes.
In this case, my lord, I am for the appeal. But you will take it up.
Already for 30.
Yes, that is right.
Fix a date, 14 November.
14 November may not be possible. This is of course 23 matter. No, sorry, 19 matter.
2nd of December, if possible.
2nd of December. Sorry, possible? No.
Okay.
As agreed by learned advocates of both the parties, recess and list the matter on
2nd December.
2nd December.
Hello.
Next week.